We have our first session today at the Maple Hall on War Crimes and International Criminal Court. I request Honorable Chair and all the panelists to be seated on the dais. So this session will be chaired by Professor Anju Wali Tikku, Head and Dean, Faculty of Law, Delhi University. She serves as the Head and Dean of the Faculty of Law at Delhi University. She has over 23 years of academic experience, specializing in criminal law, public health law, and human rights. She completed her PhD in 2003, focusing on the socio-legal aspects of organ transplantation in India. She has previously taught at National Law University, Delhi. She is a visiting faculty at the Indian Law Institute, Jamia Millia Islamia, LNJN Institute of Criminology and Forensic Science, and the Delhi Judicial Academy. Professor Tikku played a pivotal role in assisting the High Court of Delhi in formulating the guidelines under the Transplantation of Human Organs Act in 2007. Her expertise also led to her invitation as a resource person to discuss the national draft policy on the criminal justice system in collaboration with the Ministry of Home Affairs in 2007. She will be chairing this session on war crimes and international criminal court. Over to you, ma'am.
Thank you, Afif. With a small input, maybe. It's not 23 years. You have downloaded that from a website which is old, and it's now. Say since 1989. Maybe you were not even born then.
No, I was not. I'm sorry.
Thank you very much for that introduction. But straight away, over to our presenters. As I understand, in the session we have got 7 of them. 1, 2, 3, 4, 5. We have got 5 of them. And we have got almost 1 hour and 45 minutes allotted to us. So 15 minutes each, that would be good enough, and then we can have maybe an interaction and a question answer session, if at all there are any observations. So first and foremost, we have got Professor Rashmi Salpekar from Vivekananda Institute of Professional Studies, and the topic of her deliberation and interest and what she will be sharing with us is reparation system of International Criminal Court, issues and perspectives. So over to you, Professor Rashmi. And when we say 15 minutes, so we would expect around 12 minutes and then maybe. Sure. Yeah, please, over to you. Thank you.
Thank you. Good morning, all. Respected Chair, my co-panelists, representative from ISL, Ms. Parinit, and my teacher, Dr. Snehal Fadnavis, and my all the dear audience. So, permit me to kindly begin. My topic, which I have chosen for the day, is reparation system of International Criminal Court, issues and perspectives. So, let me introduce first, that is about International Criminal Court. We all know that it is established under Rome Statute 1998, and it came into enforcement in the year 2002. And so far, we are having 124 member countries of International Criminal Court. So, International Criminal Court, if we will refer old literature, in fact, before 1990s, in fact, then you will find that it was a distant dream actually. So, when I used to study, when I was a student, so this kind of literature I have gone through a lot of times, that whether we can have a permanent International Criminal Court or not. Because earlier we were having precedents of Nuremberg Tribunal, Tokyo Tribunal, and then after that ad hoc International Criminal Tribunal of Yugoslavia and Rwanda. So after that, whatever discussions used to take place, so in that all the experts and jurists, they used to think that whether we can have a permanent International Criminal Court or not. But then finally that particular court came into existence in the year 2002. Now, what are the unique features of International Criminal Court? Of course, it is permanent in nature, but in addition to this, this is the first a permanent international criminal court. Earlier, all the criminal courts, they were ad hoc in nature, and they were restricted only for few situations. For example, Nuremberg and Tokyo, they were having their own jurisdictions. Same with Yugoslavia and Rwanda as well. But however, this kind of constraint is not there for International Criminal Court. Of course, as per the basic principle of international law, if the consent is there of the member state, then only they are having situation. But then Security Council is also having its own space actually over there, that they can refer the situation to International Criminal Court. So therefore, we can say that this is the first permanent International Criminal Court. And the another feature which I wanted to highlight in this particular presentation is that ICC, they can award victims reparation. There is one another unique feature in relation to victim, is that victim participation in the proceedings. So it is altogether a different area. So I have referred it, but I am not going to deal with this because this is entirely a different area regarding participation of victims in the proceedings. I am going to highlight this last point, that is to grant victims the right to claim reparations before the court. So this is what is the area on which I have made a bit research. Now, what exactly reparation? How we have gone for the reparation? So in that, I would like to refer Thomas Lubanga's case. I will discuss this particular case in detail later on as well. What they said that in this particular case, that it is a key feature, means it is not only a unique feature, but it is a key feature. And according to Thomas Lubanga case also, this is one of the main feature of International Criminal Court, that in future also you will find that more state may be the members of International Criminal Court. So this is a kind of lucrative, this particular feature, because here in reparation this particular feature is there. Now this feature you will not find in any other organizations as such, or the courts also. Like for ICJ also, they give compensation, they give damages if there is injury also. So of course they are following that principle. But otherwise, for example, UNHCR. So UNHCR is dealing a lot with humanitarian aid to the refugees. But however, they are not getting reparation for the sake of that thing, that a state who is producing refugees, they are required to fund to the work of UNHCR. So that kind of principle you will not find. But in International Criminal Court, that principle is there. So it is a key feature due to which maybe the states be the member of International Criminal Court. And then the nature of the reparation is different. It is not punitive in nature. Like in daily basis, you will find that yes, compensation has been awarded, but it is not. But it is generally a kind of punishment, a kind of penalty that they are required to give the compensation. Here, the feature of reparation is different. It is as per the loss and injury of the victims, reparation is there. So therefore, as a punitive measure, you may give imprisonment, you may give some other kind of such punishments. But regarding reparation, it is only to compensate the harm to the victims. It is not a penalty as such. So therefore, the calculation of reparation is also based on that how you are calculating the harm which has been done with the victims. Article 7, these are the relevant provisions in Rome Statute. So mainly there are two provisions, Article 75 and Article 79, which is there in Rome Statute. Then there are rules and procedure of ICC, that how to implement the International Criminal Court and how their system will work. For that matter, we are required to refer ICC rules of procedure and evidence. Total 12 chapters you will find in these rules, and they are very comprehensive in nature. So in that, Rule 85A and B, and then Rule 94 to 98. So these are the rules which we are required to refer primarily when we wanted to understand about the reparation. So Article 75, that is reparation to victims, this is the article under which International Criminal Court, they award the reparation to the victims. Then after that, what is the procedure under International Criminal Court is that under Article 79, the trust fund, it is established. Now, what is the work of trust fund? In some of the literature, I have found that trust fund, they have used it, the word they have used it as intermediary as well. What they are doing, that they are required, means the perpetrator or the one who have been convicted, that particular person will give all the amount which has been stated in the reparation to the trust fund. So therefore, in various awards, you will find that ICC has used that reparation may be given through trust fund. So therefore, these convicts are required to submit the amount to the trust fund, and then trust fund will allocate it. Then in addition to this, trust fund is also having a right to get the aids and kind of donations also from the NGOs and other organizations also. So thereby they are also developing a kind of lump sum with them, and through which they are required to award the they are required to execute the reparation provision or reparation award which has been given by the court. Now, first of all, as in Article 75, it is stated that reparation is required to be given to the victims. So let's see that who are the victims under International Criminal Court. Now, for that, Article 85A and Article 85B is there. You will be surprised to know that under victims, natural persons are also coming, as also the objects are also coming. For example, the organizations also. That is 85B, that victims may include organizations or institutions for what? If the harm is taken place to the historic monuments, hospitals, other places. So in that case, even the organizations or institutions, they are also able to get the compensation or the reparation for the same. Now, why it is a surprising provision? It is because if you will see, Article 1 of ICC says that its scope is limited only with the natural persons. It means that they can prosecute only the natural persons. So thereby they recognize the principle, that is individual criminal responsibility. So therefore there is no criminal responsibility pertaining to the states and pertaining to the organizations. It is very much clear that ICC is dealing with individuals. That is also one of the unique feature. But however, while giving the compensation or the reparation, under Article Rule 85A and B, they have referred the natural persons also and also the organizations or institutions. So these both you will find under, it is coming under the definition of victims. Now, trust fund, as I was telling you, that its main responsibility is to implement the court order reparation award. So even though trust fund is getting all aids and donations from various NGOs, they are also getting the amount which will be submitted by the convict also to be disbursed to the victims. But however, the victims must be those or from those situations for which the ICC has given the award. So for that matter, trust fund, they are required to work only on those situations which are coming under the mandate of International Criminal Court, and thereby they can give they can disburse the amount, and plus they provide the assistance to victims outside the scope of court order reparations. Now, what is this outside the scope of court order reparations? It means that the situation is with ICC, but however, yet ICC has not awarded any reparation for the same. Yes, this is the alarm. How much time is left? Oh, really? Okay, I will run now. So, so trust fund, they are required to give assistance even outside the scope of court order reparations as well. Okay, now the types of reparations are like monetary compensation they can give, return of property is required, rehabilitation, medical support, victim services centers, and symbolic measures like apologies, or they will build some memorial in the memory of those who have lost their life and property. So these are the types of reparations which can be given under Article 75. It means that under Article 79, trust fund is required to disburse the reparation amount for in this particular and for this particular purposes. So if you will read the judgments given by the ICC, you will find that they are very particular that what to do, whether to return the property, whether to rehabilitate, whether to give the medical support. For example, in the case of Thomas Lubanga, wherein child soldiers have been recruited by Thomas Lubanga and thus thereby he was punished. So for that matter, they have explicitly written that ICC what they wrote, that the reparations have been given in favor of those children who have been recruited as child soldiers, and for their future also they are required to work. It also includes schooling, education, etc. So now what exactly has been done in Thomas Lubanga? So Thomas Lubanga, he found guilty in 2012. Then he has been told to give reparation in the year 2017. This is the first case wherein the reparations have been given. In 2019, it was confirmed also. Total 425 victims have been identified, and they found eligible. Now this is also the work of trust fund to identify that who are the victims. So that also work has been done by the trust fund, which is coming under International Criminal Court. And then ICC, they have given the collective service based reparations for the victims, include mental and physical health, etc. In another case, this is what is Katanga's case. In Katanga case also, now you please note down the amount also which has been given. For example, in Thomas Lubanga case, it was like 10 millions which has been awarded as a reparation. In reparation of another case, that is Katanga's case, again 3,752,620. This monetary value has been told Katanga to be paid. And then further, they have also said that symbolic compensation to be given, that is USD 252 per victim. Around 297 victims they were identified in Katanga's case. Now Ahmad Al Faruqi, that is also called as Al Mahdi, he was also found guilty. This is the third case, and he was found that he has attacked on historic and religious buildings in Timbuktu. So I was telling you at 85A, 85B. So here, as per 85B, the victim is those religious buildings who have been targeted. So therefore, the compensation have been given. This is the first case wherein cultural property related reparation have been given. Now in this case also, they have given 2.7 million euros. Then next case is about this is about Bosco's case. He was a former deputy chief of the staff. Now here USD 30 millions have been given as reparation. Then next case, this is the latest case, and this is the case by Ongwen. And actually because of this case only, I thought that I should take up this research problem. And here 52,429,000 they have been awarded as reparation. This order has been given in this year only, on 28th of February 2024. They are allowed to go into appeal, yet that decision has not yet come. And they have given the division also, that how many collective reparations will be there, how many symbolic award will be there, and other community measures also. So thereby they have come up on 52 millions figure. Now here, what exactly the trust fund is doing? So far, trust fund has given or provided assistance to over 120,000 victims in various countries, mainly in Uganda and DRC. At present, they are working on 32 projects. They are taking a lot of help from NGOs, states, etc. Now here the issue and challenge. What are the issues and challenges? Now here ICC is based on completely individual criminal responsibility. Article 75 says that the convict is required to give the reparation. The role of the trust fund is the assistance in disbursing the amount to the victims. Now, what if the required amount is not available with the convict? If you will see all these, like Thomas Lubanga for that matter, he expressed his inability to pay such a huge amount. And even in other cases also, same thing happened. And if you will see the economy of those countries, so the economy of those countries is also not very high. So therefore, it is really doubtful that whether these convicted person, even though they have committed a crime, no doubt, but whether these people will be having enough this kind of amount or not. Ongwen, in this particular reparation amount is a kind of historical amount which has been given or awarded, because for 50,000 victims they have identified in this particular case, and 52 millions they have asked Ongwen to pay. So therefore, it is very much difficult for any convicted person to give that much of reparation. Now here I am not doing any advocacy for those convicts because they have committed international crimes. But then we are also required to see that this court is victim-centric court. There are a lot of expectations of victims from ICC, and we are saying that maybe more states will become the member of ICC because this feature is there. But if this hefty amount will be there, then in that case, how we will be able to see that yes, it will be implemented? So now all responsibility has been transferred or shifted to on whom? Trust fund. Now what trust fund is doing? Trust fund is also asking for funds to various NGOs, to various international organizations. Now here, what I wanted to say that here maybe now the work of trust fund is getting overlapped with other organizations. If you will see UNHCR has spent millions and still they wanted to have some more millions of money for the sake of Uganda and Congo. So in both of the countries, wherein all these perpetrators, they are also belonging to nearby countries, mainly Uganda and DRC, that is Democratic Republic of Congo. UNHCR has also spent huge money for the rehabilitation purpose. For Congo, also they have spent money. In fact, UNICEF, as children are involved in this, like child soldiers. So if you will see UNICEF is also working for children in Congo, including those who have been recruited as child soldiers. So here my suggestion is that somewhere we are required to go for collaborative approach. If we will see international organizations, including courts, vertically always, then in that case, if you will see that the mandates, they are getting overlapped with each other, and all these institutions or organizations, they will do their work isolatedly, but then ultimately who are getting benefits, how much they are getting benefits. So maybe the victims, they may not find themselves in the list of UNHCR also, in the list of UNICEF also, and in the list of trust fund also. What about those victims? So therefore, if the assistance, this particular thing is we required from trust fund, then in that case, we need to have a collaborative approach with the other organizations. So this is what is my suggestion. Thank you so much.
Thank you, Professor Rashmi. I believe we will take the question answers or maybe interjections towards the end of the session.
Yes, ma'am.
May I now invite the next speaker, Shubhamanyu Lahiri, and his topic is the Security Council's shadowy hand, the dark side of referral powers in the International Criminal Court. Over to you, Shubhamanyu.
Thank you, Chairperson, and greetings to the August gathering. I will be presenting on the topic, which is the dark side of the referral powers of the Security Council, and more on the relationship between the United Nations Security Council and the International Criminal Court through the power of referrals, and a little bit on the deferral side.
Sorry, Shubhamanyu, would you please introduce yourself first?
All right. So I am Shubhamanyu Lahiri, and I'm a fourth year student at Jindal Global Law School.
Great. All the best.
To begin, the concept of an international criminal court is something that's been spoken about ever since the creation of the Nuremberg tribunals, because of the inadequacies of those tribunals and the kind of arguments that were posed against those tribunals. And eventually such deliberations led to the creation of the ad hoc tribunals in the former Yugoslavia and Rwanda in the 1990s. And that also helped gain a lot of steam for a permanent international criminal court, with more and more ad hoc courts coming up, and the kind of budgeting and the spending that was going to that, and the limitations that these ad hoc tribunals had, led to a more concrete requirement for a permanent international criminal court. So with that, the International Law Commission eventually came up. I'm sorry. So with that, the International Law Commission came up with a draft article on the statute of the ICC, wherein it talks about the Assembly of State Parties maintaining a relationship with the Security Council, and under Article 23, Paragraph 1, they talk about the referral powers of the Security Council that shall come under Chapter 7 of the Charter of the United Nations. Uh, the appendix also talks about the kind of possible relationships that the court could have with the ICC, with the first option being the court as a principal organ of the United Nations. However, in the draft article itself, the International Law Commission expressed disdain on the idea because of the kind of budgeting and economic restrictions that that the United Nations would face, and because there was no precedent of a court being created after the ICJ was created, but that was the part of the initial UN structure of a court joining the United Nations as a principal organ. The court also talked about I'm sorry, the council also talked about the court being a subsidiary organ of the United Nations. And that idea was more favorable to the members of the International Law Commission because there is precedent on the same, because the ICTY and the ICTR are looked as the subsidiary organ of the Security Council, as it was created through UNSC resolutions. There was a third option, which was that the court does not become a part of the United Nations structure at all and is set up by a treaty as we see today, and the relationship between the council and the court happens through resolutions and treaties. Oh, thank you. So now we come to the Rome Conference in itself. So the state parties there and the members who were present in the Rome Conference decided that the ICC would be an independent body, an autonomous body, would have a relationship with the Security Council, but would not come under the ambit of the United Nations itself, which actually led to a lot of superpowers back then, such as the US, Russia, and China, to not join the International Criminal Court. A lot of them signed, but eventually did not ratify as well. So, there were two kinds of relationships that were accepted under the Rome Statute, which is Article 13b, which talks about the referral powers of the Security Council, and Article 16, which talks about the deferrals of the Security Council. So, with that, we come to Article 13b, which talks about situations which are referred to the court by the Security Council via a resolution under Chapter 7 of the Charter. This allows the International Criminal Court to launch a preliminary inquiry and later an investigation into cases where it normally wouldn't have jurisdiction, because the states were not state parties to the Rome Statute. So this is the kind of universal jurisdiction that has been provided to the International Criminal Court, but it can only happen through a Security Council resolution. Furthermore, this is the only method where a non-signatory state can be investigated and later its individuals prosecuted in any scenario. Then we move on to the two cases where it was actually applied. We would talk about Darfur, Sudan, and then Libya. So in the picture you can see Omar al-Bashir, and next to him Muammar Gaddafi himself. So just to give a brief situation, in Sudan, they had been in a civil war since the 1983s. There's been ethnic divisions between the Arab population of the Darfur region, of the northern Darfur region, and the non-Arab or ethnic African populations of the southern Darfur region. And it's been a conflict ever since, and even after the ICC intervention, it unfortunately is still going strong today. With that, we come. So there was an international commission of inquiry on Darfur, which found out that these participants, be it the government, be it the rebels, or be it the militia that were hired by the government, had committed crimes that are mentioned under Article 5 of the Rome Statute. So eventually we come to the UNSC Resolution 1593, which referred the situation in Darfur to the ICC. Now there are two paragraphs in this resolution in the operative part which are important, because one, paragraph 6 states that the ICC referral is limited only to Sudanese nationals and that any actor in the situation who's a non-Sudanese cannot be prosecuted or investigated by the ICC. 7 is that it explicitly states that it will not be providing any economic benefits or funding to the ICC for its investigation that the Security Council itself has referred to. This eventually leads to a separate treaty agreement, but that was after a lot of deliberations and arguments because of the inability of the Security Council to fund anything. So then we come to the significance of the Darfur situation with regards to this relation, because the Darfur situation became the first ever case where a UNSC referral under Article 13B was practiced, and a non-signatory state was brought under the ambit of the International Criminal Court for the first time ever. This is also the first time that a sitting head of state was charged by the court, and there was an arrest warrant issued on Omar al-Bashir, who was then the sitting head of state of the state of Sudan. Also, interestingly, this was also a situation wherein the existing opinio juris of head of state immunity was challenged and later held that it would not be applicable in ICC cases because, just to give a brief of the situation, Omar al-Bashir had gone for an OIC conference in Jordan, and Jordan, being a state party to the Rome Statute, chose not to arrest him. Eventually, they were brought under the ambit of the ICC for not adhering to the ICC norms under Article 87, Para 7 of the Rome Statute, and it was held that the head of state immunity would not be applicable on Omar al-Bashir. Now we move to Libya. So Libya was one of the epicenters of the Arab Spring in 2011, and eventually there was a mass movement against the sitting dictator at the time, Muammar Gaddafi. So eventually Gaddafi, to quash such a rebellion or a revolution against him, committed war crimes and crimes against humanity on his own people, and eventually was brought under the ambit of the International Criminal Court. The situation in Libya is still tense. It has been a civil war for quite a few years now. So again, there was a report on the same which charged the Libyan government nationals for crimes under Article 5. Now we come to the UNSC resolution, which was a very long resolution with multiple appendixes as well, which talk about his Gaddafi's bank accounts being frozen, his there was travel bans against him. But again, more importantly, we come to two specific clauses, which is one which decided that only Libyan nationals could be prosecuted in the ICC and no non-Libyan prosecutions can take place in the ICC. And once again, no funding from the Security Council or the United Nations at large. Now, since this was the second time that the UNSC referrals took place, this caused a lot of widespread criticism as not just the African Union, but a lot of the third world states and third world people were starting to call a bias of the Security Council and even of the court for that matter against the African nations. Since back then and even to this day, all people charged in the ICC, individuals that have been charged in the ICC are all of African origin. There was also a lot of criticism for the kind of structure that the Security Council is, wherein 3 permanent members who are very influential in Security Council affairs, US, China and Russia, can send such referrals to the ICC, can make decisions pertaining to the ICC but are not a part of the ICC. So this eventually led to the African Union calling out such kind of power imbalance and a bias, and eventually leading to them passing a resolution requesting states to withdraw from the ICC. Eventually one of them did. So Burundi was once a part of the ICC and they withdrew from it. Now we come to the Article 16 of the Rome Statute, which is deference. So here we see that any investigation that has been started by the ICC can be deferred for a period of 12 months if the Security Council passes a resolution for the same, and then can be deferred for a further period of 12 months if there's another resolution on the same effect. And the same is inexhaustive. As long as there are resolutions, it will be deferred. Now, we come to two particular cases which such deferral powers were used, and I will lay both the resolutions bare for you, just to show that there is no difference in the wording and structure at all. Because especially what is important here is paragraph 1. It states that if a case arises involving current or former officials or personnel from a contributing state not a party to the Rome Statute over acts or omissions relating to a United Nations established or authorized operation. Now, why this becomes important is that you can see the number of the first resolution, resolution 1442. Now, this becomes important because the United States Secretary of State in a press conference had stated that they had attacked and invaded Iraq to enforce resolution 1441, which talks about certain requirements and obligations that the state of Iraq needed to fulfill. They also labeled their acts in Iraq as a UN mission, which the then security UN Secretary General Kofi Annan denied. But that was the United States excuse. They eventually deferred the situation again in resolution 1487. But since then, there have been no deferrals because any case of a future deferral would then be vetoed, which we would also look. So there were certain attempts at referrals and deferrals which did not pass. So, for example, the Security Council failed to adopt a draft resolution referring Syria to the International Criminal Court. It had the majority, but as was the widespread criticism, two permanent members of the Security Council vetoed it. The Security Council also failed to adopt a draft resolution deferring the Kenyan leaders' trials in the International Criminal Court. So, but in this case, it failed to adhere to the required votes. So, with this, we can see that there have been a lot of issues and problems that have come through the United Nations Security Council referral mechanism, as well as deferrals for that matter. So, although there are methods of restructuring or reviewing these issues and problems, however, at the present stage, considering how the Kuala Lumpur conference went, I would say most of them are very idealistic in nature. Thank you.
Thank you, Shubhamanyu, for adhering to the timeline and talking about the deferral and referral powers of the ICC. The third speaker for the day is in this session, Bhumika Nanda, on feminist engagement and inquiry into the working of the International Criminal Court. Over to you, Bhumika.
Thank you, ma'am. Good morning, everyone. My name is Bhumika Nanda and I'm an assistant professor at School of Law, Bennett University. This is what I'm working and it is part of my research, which is kind of ongoing till now. So I'm looking at feminist engagement with the origin, rationale and practice of the international criminal law, and I have divided this entire paper into two parts. If you look at the Rome Statute, for example, it has been advocated to be more of a feminist statute because it has envisioned and incorporated so many articles related to gender and especially women, in fact, due to also the campaign which was put forth through the women's organizations and also human rights NGOs. So that is one part of it. But so far as my presentation is concerned, it is divided into two parts, which has been dealt also by the previous presenter here with regard to the nature of this International Criminal Court or the Rome Statute. Can we call this Rome Statute to be something which is international in nature, for example, trying to build up on the peace and security, or should we call it to be a delegation of state? So how can an international body have a right to punish somebody which is technically originally being considered to be a state responsibility and not an international organization responsibility? So if you look at the other international organizations which are there, they are dealing with the political matters, interrelation between the different states, but are not punishing it. So how can all the states in fact agreed to give one international body that right to punish it, which is sole authority of a state. So that is one part of it. And second is that even if you believe it to be either an international organization having that power of punishing it, which is us punendi, the second question is that how far they are actually able to land on their feminist agenda. So that's where my presentation is in twofold manners. So looking into the first, the Rome Statute, when it was established, it is looking at two kind of aims and missions are there. One is collective in a manner of building and maintaining international peace and security, and the other is individualistic in the manner is and making sure that those people who have violated and committed heinous crimes will be put also to task. That's why it's a combination of, as I stated, both. It's not a public international law entirely, but also has a criminal matter into it and a very strong grounding into criminal law. So the principles of legality is something which has been practice, and the fairness and culpability has been practiced by the ICC. And we see that how when the judges are focusing more on the principle of legality are also losing on the ground of feminist agenda. So 2 and 3 different goals which they have put into their preamble are actually pulling them apart and not focusing into one direction. Many a time it has come through the cases which have been decided. So this is what my 2 issues are, which have already been stated. And so the question of legitimacy comes is that can they in fact have this kind of a legitimacy to do? And even though we have a Rome Statute, which is kind of a treaty between the different states, and they can give consent to establish the International Criminal Court, the question comes, is it legitimate enough to do that? Because looking into how they have exercised their power, how they have choose to initiate prosecution and investigation to some of the states and not into the others, raises the question on their legitimacy. The Jus Punendi is something. So there are different authors are there. I'm taking note of Kai Ambos, who has been a propagator and a positive in terms of building on to the International Criminal Court. And he stated that when you talk about Jus Punendi, the state has it because all the states have come together on the ground of Kantian's principle of human dignity and making sure that who have violated the human dignity of people should be put to task and been punished for that. That is where the collective response of everyone has come, and that what gives the power to International Criminal Court to prosecute those criminals. And that's what has been used to justify the referral even by the United Nations Security Council over to the states who are not member of the ICC. So it kind of takes away also onto the state sovereignty and takes away the wheel of state sovereignty and try to infringes onto the their territorial integrity by making a referring the matter. Sorry, I'm not following the slide not reading from the slide, but taking it. And that's the reason why the community of the world is also questionable because of the conduct of many, the way the prosecutor and the Security Council have functioned it. If we look at that, and that's a reason it has been called as a giant without arms or legs, because the Security Council is the kind of power they have been given within the ICC to refer, defer, and also the fact that the association of the state parties is something which is funded heavily by the European countries and by the USA and UK, who themselves are not a party to the ICC. So that raises a lot of concern as to whether it is actually a community of the world kind of a court or again propagating their sole agendas. That's what has been stated. The third point, in fact, the 2 I've already stated. The third point is that now look at USA, who signed it and did not ratify it later on. And in fact, claims to have unsigned a document which has never happened in the history of the international treaties, has all the more entered into bilateral treaties with the different countries who are party to the ICC, allowing immunity to their own nationals. So if their own nationals are involved into the territory of an country which is, conflict dreaded and is a party to the ICC, they can't now take jurisdiction over the nationals of USA because of this bilateral treaty. So the double standards, in fact, which has been built into the ICC structure, it needs to be questioned, and that what takes the authority or the legitimacy of this ICC entirely. This has been stated by the previous presenter also, that we have majority of the cases focusing on the African states, no doubt. However, out of that, 6 are referred by the states themselves. So that is also one way through which we can say that it's not that they are actually picking entirely all, but even the African states are going through that kind of a turmoil, the stability into their state, and that's what is that's why they're also coming and looking forward to the ICC to give them those judgment which they're looking forward to it. However, the legitimacy makes it difficult for them to actually give that much or put their fate into this structure entirely. But these are the examples which are non-African states, however, taking a lot of time when it comes to the ICC's inquiry to be set up. So Afghanistan, which was earlier being refused, now being taken to be again get into the investigation, is something which is taking its own time as compared to what an African state has been done. Palestine, again, is a slow motion process because of the interest of the members, permanent members, especially of the Security Council, that it has not taken up as compared to the African state. So the timeline which they are taking it actually shows, it shows a bias which they have it in non-African states, and also where the major powers have their interest. The third world, and that's the reason why the third world who are looking into the ICC has question on the universal character of the International Criminal Court. They are saying that it is not universal in nature, in fact again leading to the marginalization and trying to dominate the underdeveloped countries, in fact, in the name that they can't manage themselves, and that's the reason we have to make sure that be taken care by themselves, for them. Further, coming into the second part of my question, which is on looking into the feminist inquiry. Now, what the ICC does that is that in its preamble, it has looked into, it says, okay, we are going to punish and we want to build up the international peace and security. However, they also have said that, okay, we are complementarity. We allow the national states to take up the agenda if they are willing and able to do that. However, where they are not willing and unable to do that, we are there for them and we can take up the matters. Now, this complementarity is something which, even though it has been shown there, the question comes in as to whether the national, the laws or the nation who is willing and able to take up the matter is having that much of a structure being available in the domestic legal system. Also, whether they have the system, domestic legal system, something which is not gender bias, have those kind of laws which are available, which are treating women, men, even the the third gender or the who do not want to fit into this binary into a proper manner. So you can't apply or enforce complementarity unless and until you actually look into the domestic laws and see they are genuine enough to in fact able to deal with such matters. So the many of the judgment which has been decided, being Lubanga, Bamba, Ongwen, in the recent one, in fact, has a kind of a tussle between two agendas. One is of a feminist judging as well as on a principle of legality. So even if the judge is trying to interpret the matter in a feminist manner, it's like looking into trying to read between the lines and see that they can give more they can give more, I would say, due to what is there onto victims. For example, I'll take example of what is being done in Lubanga, where they talk about conscription of children in the armed conflict in the army. So now what happened is that in Lubanga case, they say that the children who are conscripted in hostilities needs to make sure that they are actually being used as a target during those hostilities between the different states, and then only you can make them liable. That is one. But if those children are not only put into hostilities with the opposite armed group, but has been abused sexually, the question comes in, can that sexual abuse or that sexual harassment which has happened to that can also be come and charged as an offense separately than the conscription of children. So that is where the pull happened between, in Lubanga case specifically, between the judges who were trying to do the feminist judging as well as the principle of legality. They say you cannot interpret that particular clause in such a manner to include sexual violence which is happening by their own armed groups. So that's where the majority went in, even though we have a minority decisions. So I'll take you to that point. This is the positive part which is there to the preamble. Different agendas are there, I've quoted here, in terms of the Rome Statute. And one of the most important thing is your Article 21 Clause 3, which is an applicable law. The applicable law have stated is that whenever the court is applying and interpreting the law, that has to be inconsistent with the internationally recognized human rights and has to be done without any adverse distinction which are founded on the grounds of gender. So this is which can be used by the judges to do a feminist judging, interpret the law or the fact finding, as well as look into the evidence, giving more regard to those kind of intersectionality, in fact, where the women or the men are being discriminated on multiple grounds. So this was done in Lubanga case by a minority judge in the dissenting opinion, where she said that I cannot read conscription of children in hostilities to be only when they are put as a target by the opposite party and not have the sexual violence being done against them by their own armed groups. But she was in the minority, and that's how the was not being given. The Lubanga was not being charged for sexual offenses and the rape, but only for the conscription of children who happen to be participate in hostilities. These are different articles which are there, which shows us that it is possible to have a feminist judging in the ICC by the judges of the ICC. However, it will take a lot of time for the judges to, in fact, come to that point. One notable point in this case is we look at the article. The fourth point and the last point, in fact, they're looking at 2 points. They're looking for a fair representation of the judges to include male and female judges. And second, they're also are looking forward to those judges who are having an expertise into gender issues, not entirely but necessarily. So it's not a compulsory component, but if they have it, that would be a good thing, that they have the expertise in the sexual violence against children and women. They are not using the word gender here. Gender is being used only for the prosecutor but not for the judges. That has been given here in the second paragraph. So though it's a great thing that they are looking for an expertise, however, it is not a compulsory component which the states have to consider when they are appointing the judges or nominating the judges for the position of ICC. Second thing which is there, considered to be a compromise between the different countries who were coming up, who has a orthodox way of looking at the gender and the one maybe looking into little progressive, is that they are limited the meaning of gender only to mean the binaries only, men and women, and nothing else other than that. So this, though it's a compromise within the text of the gender, but still allows the court to do a feminist judging and interpret the law looking into different the intersectionality with which a man or a woman would face. These are the judges which I have already stated, but it is there for you to read. In Lubanga case, Justice Odio Benito was the one who actually said that by reading the law, the clause in such a manner, the article in such a manner, they have actually rendered sexual violence as invisible. So what happened in Lubanga, as ma'am stated, they have given the reparation to the victims. However, when the victim comes, the harm was not been recognized so far as the sexual offenses are concerned. So that's where, though they are progressive and having this reparation and compensation to be given to the victims, how they classify it as to who are eligible to be included within the victim bracket is something again gets limited if they do not apply their mind in the interpretation by using the asking the woman question or doing a feminist judging. Similarly, Natanga was one case which happened after, in fact, Lubanga. In fact, they were dealing with the same country. The little bit of interpretation which was given in Lubanga got accepted in Natanga here, and they allowed that when you are conscripted children in hostilities, it will not only include them to be only a target by the opposite counsel, it can also include where they're using these ladies, women in fact, or the girls in fact, to go to the opposite armed group members and kind of enter into reconnaissance mission, that is like alluring them through the means of sex to give certain information. So if that is being done and they being compelled by their own armed forces to do that, will be considered as one of the offense in the offense of sexual offense against the members. So this is a broader one than what has happened in your Lubanga case. Though they are still not telling that when the members themselves are committing sexual violence against their own children who are being conscripted, whether that can be included or not, is the judgment is again silent. Again, if you look at Dominic Ongden case, it is one case where they actually, in this case, what happened is that there was one lady who earlier when she gave her evidence with regard to the sexual violence, she denied it, but later on when she came before the judges, she actually explained that okay, it has actually happened, but I couldn't tell beforehand because the people who were taking my evidence were all men and I was not feeling comfortable to do that. So this is one case where the judges allowed that evidence to be taken by the witness even though it was not same as what she has given. So the court agreed that there could be different social context could be there, which actually makes it difficult for a woman to come forward and tell about what has happened to her, and therefore we need to take that experience into account when they are deciding on either the reparation or the guilt of the party. So we have a mix of judgments, in fact, where they are letting gender or based judging to enter into the realm, and also where they are very much careful, making sure that the principle of legality is not getting infringed. And that's where we have to see as to how long they can adhere to those people who are on the margins, in fact, and might get affected due to this structural biases which the any institution has it, because all of them are in that sense are of masculine in nature and are trying to be now reworked into more of an open gender interpretation. These are again two cases, I'm not going in detail, but we see that how the Bemba case, which was the first of the case before the ICC, they allowed and they recognized that he has committed as a leader and allowed it to be committed in his province. The offenses of rape and sexual violence was later on been equated by an appeal chamber because they couldn't find enough of the link to make him guilty. Similarly, the recent case in June 2024 is with regard to Al Hassan of Mali. He was also been accused with regard to the sexual violence and the sexual slavery. Again, the trial judge said that there is not enough link to make him responsible with regard to those offenses. So the manner in which the evidence has been taken and the facts are being founded need to be made more gender oriented instead of following the traditional and orthodox manner of investigation. That's all from my side today. Thank you, ma'am.
Thank you, Bhumika. The next presenter and panelist is Himanshu Yadav. Tethering the elephant in the room, hitch and headways in defining the crime of genocide. Himanshu, you also have got 15 minutes to begin with? Yeah, please.
Good morning to everyone present. I'm Himanshu Yadav. Currently, I am pursuing my doctorate from JNU. My topic is on tethering the elephant in the room, hitch and headways in defining the crime of genocide. So, genocide as a concept, as a practice, has been there since the advent of human civilization, often dubbed as the crime of crimes, as by the best scholars in international criminal law, William Schabas, and the odious scourge by the Genocide Convention as well. The crime which is the epitome of human evil, the darkest of humanity's inhumanity. So all these epithets go on to buttress its colossal dominance in international criminal law in general. Now, the reason why I'm calling it an elephant in the room is because genocide is not a rare occurrence, as in it happens once in a blue moon. But then, as we see the situations unfolding in the current international regime, particularly if we see the war crimes, the armed conflict which is happening in Russia-Ukraine war, the Israel and Gaza conflicts, the conflicts in Nagorno-Karabakh region in Armenia, which is perpetrated by Azerbaijan, and the issue of Rohingya genocide perpetrated by Myanmar. all these go on to buttress that yes, genocide is definitely the elephant in the room, and it must be tethered so that it does not go berserk. And that is the whole point of taking up this topic, which is a very contemporary topic in that sense. And the problem is of defining. So how do we define genocide? Because again, how do we define genocide will have ramifications for how we diagnose and how we apply this concept of genocide to particular issue areas. And for that matter, if we see, there is this scholar who is credited with coining this term genocide, taking from the Greek root genos, meaning race or tribe, and the Latin suffix sede, meaning killing. So killing of a group or family of people is known as genocide. This was coined by him in 1944 in his book Axis Rule in Occupied Europe. But then, as is the general criticism of international law, that it is very much Eurocentric. So that is why it is very pertinent to have a third world approach to international law and international criminal law in particular. And defining genocide is not something which was initiated by Raphael Lemkin, as is the claim which is there in the research on the point. And particularly the fact which I want to say is that there is this gentleman who is Pandit Jona Raja, who has tried to define the crime of genocide even before Raphael Lemkin had coined the term in the 1944. So that is how I try to bring in the third world approach. And I must say that the work of this gentleman is conspicuously absent in the literature of dealing with the genocide. So Jona Raja was a Kashmiri Bhatt Brahmin who coined this term very similar to genocide, what he is calling as Jati Vidvams. So Jati and Vidvams, very similar to the origins of the word genocide from genos and sede. So again, if we look at the etymological meaning also, it seems like Raphael Lemkin has somehow taken inspiration from this scholar from the India. Now, Jona Raja was the author of the second Raj Tarangini, and he was the author of Raj Tarangi, one after the written by Kalhan. So that Kalhan is someone we all know, but Jona Raja is someone we don't know very much. So as somebody, some people, and I know Kanika ma'am is from Kashmir, and so she might know it. So he is also, coining this term. He has even pointed out the special intent that motivates the perpetrator, and given a very sensitive and vivid account of how an ideology radicalizes a regime and affects a total change in the modes of operation that leads to genocide. He has made it clear that the mind of a perpetrator is at a very low level of maturity. That is the view held by the present day genocide scholars as well. He has defined genocide, and his definition is almost equal to the definition given by Raphael Lemkin. So again, that is a perspective which I wanted to highlight. Now, the efforts to define genocide were spearheaded through the efforts of Raphael Lemkin, not to forget that matter, particularly his role in the adoption of the UN Convention on the Prevention and the Punishment of Genocide, 1948. But then Third World has also a role to play in that matter, because it was the efforts of countries like India, Panama and Cuba who spearheaded, who wanted this agenda to be taken up before the UN General Assembly. And eventually the UN came up with this 1946 resolution which tried to define genocide in a very broad sense. Now, this resolution contained two significant elements. First, it contemplated the genocide of political groups, and second, it defined genocide through an analogy of homicide. The definition established the characteristics of the event through the type of crime committed, and not through the characteristics of the victim, racial, religious, or political, are simple examples, and other term completes the categorization. So again, they are not confining their definition to any specific protected group, but then dealing with the groups in general, humans in general. But then we come to the most ubiquitous definition of genocide, which is now even present in the Convention of the Prevention and Punishment of the Crime of Genocide, 1948, and then which is eventually adopted by the Rome Statute also under Article 6 of the Rome Statute. So This is the most important definition of genocide as far as the legality principle is concerned, and this is where the concept of genocide has been hitched. So that is why I am calling it hitch and headways. So if you see the definition, it defines genocide as: in the present convention, genocide means any of the following acts committed with intent to destroy in whole or in part a national, ethnical, racial, or religious group as such. And then they are laying down the different 5 parameters, of which the first 4 are dealing with the physical destruction and the last one is dealing with non-physical destruction. So this definition, as is evident from the reading of the Travaux Preparatoires, which is the negotiations leading to the adoption of the treaty, it is clear that the inclusion of social and political groups would jeopardize the acceptance of the convention by a large number of states that did not want international community to become involved in their internal political struggles. So again, we see that the main criticism of this definition is that it is only dealing with these 4 protected groups, which are based on the grounds of nationality, ethnicity, race, and religion. So it in a way, makes this definition a very narrow definition and very difficult to apply it to the specific case scenarios which we have in hand. So Raphael Lemkin, who had played an important part in the drafting of the convention, overcame the deadlock in the negotiations by arguing that political groups should be excluded because they lacked the cohesion or permanence of other groups. After arduous negotiations, it was finally decided that the protection of political and other excluded groups should be guaranteed by national legislations and specifically the UN Declaration of Human Rights. So, thus, the United Nations defined genocide as a new legal typology explicitly stated in Article 2 of this convention. But by excluding the political groups, definition of genocide became arbitrarily restrictive. For example, religious belief systems are protected, whereas political belief systems are not protected. So, again, there is this one very important principle of equality which is not being followed in this definition. So, you should not make any difference between different groups of humans. So again, here the principle of equality is not being followed because it is only 4 groups which are being protected while the other groups are not getting the same protection. Now the most important objections to this definition are that the convention excludes targeted social and political groups. The definition is limited to direct acts against people and excludes acts against the environment which sustains them or their cultural distinctiveness. Proving intention beyond reasonable doubt is extremely difficult because the proof of the dollar specialist or the special intent is very difficult to prove, as we are seeing it in the cases which are unfolding right now. And that UN member states are hesitant to single out other members or intervene, as the case in Rwanda. The difficulty of defining or measuring in part and establishing how many deaths equal genocide. So all these are, the challenges with regard to the definition of genocide under the convention. And it is basically for this reason that different scholars have tried to come up with alternative definitions of genocide. So they are coming up with what is known as politicide or political genocide, cultural genocide, ethnocide, ethnic cleansing, democide, and classicide, eliticide, and all these terms and expressions to cover hitherto uncovered cases of genocide. And there was this commission, the Whitaker Commission, which made important recommendations in this regard. That it proposed that the radical changes to the convention by means of an additional optional protocol. Proposals included the protection of groups based on political and sexual orientation as well, and the prohibition on ethnocide and ecocide. But then it received a very lukewarm response, and the convention still continues to exclude political, economic, social, and sexual groups. Now, the Rome Statute came into the picture in 2002, and it continued with that definition under the Convention on the Prevention and Punishment of the Crime of Genocide. And that was a very sorry state of affairs because the nation states tried to broaden the definition of the genocide under the convention, but it could not see the light of the day. But then there has been a rich reservoir of cases through by the way of judicial interpretation by the courts, the international courts, wherein they have broadened the scope of genocide, if not the legislative mandate under Article 2 of the Genocide Convention. And in this regard, there are various cases of the International Criminal Tribunal for Rwanda and the International Criminal Tribunal for Yugoslavia. Also, as I said, scholars have attempted to give their own definitions of genocide, and they have tried to broaden the scope of genocide. But then the definition given under the convention has stood the test of time. But then it has to be said that now the time is ripe that the definition under the convention should be broadened to include hitherto uncovered protected groups and follow the principle of equality before law. So this is a Kwibuka Flame of Hope monument installed at the UN headquarters. This was recently installed at the UN headquarters in New York. This was gifted by the Republic of Rwanda to the UN headquarters. And Kibuka is a Rwandan language term which means to remember. So it is a remembrance of the Rwandan genocide which happened in 1994. And this flame of hope is again a hope. They are expressing that that from this hope, from this flame of hope, we must be able to ignite our notions and our and introspect and have a definition which is more encompassing and it and is easy to apply in the specific case scenarios at hand. The recent case of South Africa versus Israel is a very important case on the point as to how the law will evolve on genocide, because as I see it, the law on genocide, the definition on genocide, the jurisprudence on genocide has evolved through case studies. So it was the first case study of the Holocaust which happened in the 1940s, which led to the adoption of this convention. And then eventually the Rwandan and the Bosnian genocides in 1994 and 1995, which led to the broadening of the definition of genocide by those international criminal tribunals. And now we have the third case study in the light of this South Africa versus Israel and Gambia versus Myanmar, through which the courts will be having this opportunity to shed some light on the jurisprudence of genocide. And till the time I say this, there has been a issuance of the provisional measures by the ICJ with regard to South Africa versus Israel, wherein they are again facing the problem of how do we apply the definition of genocide to this particular case at hand. And they had to even shy away from the fact of calling the activities there as genocide per se. They have just called it as plausible case that genocidal activities might have been committed. So still the matter is up for consideration, and the matter will be decided on merits in due course. But then we can only hope that the promise of never again is fulfilled and is seeing fruition both in letter and in spirit. Thank you.
Thank you, Himanshu. And now we open up the floor for discussion. Any observation, any interjection, anybody would like to pitch in or ask a question, then maybe I would give few pointers. And please be very focused with reference to the question as to whom it is being addressed, and be very precise. Thank you.
Hello. My name is Walter. I'm a legal intern at the Ministry of External Affairs. Thank you for this wonderful panel. I have two questions, one directed to two different people. Can I proceed? Yes. First is to Professor Rashmi Salpekar. Ma'am, I understand that you have focused a lot on the compensation and how it plays out, sometimes imperfectly in the case of TFB, and sometimes there is not enough funding, and you had focused a lot more on the collaborative efforts to bridge the gap. I wanted to ask if there was any idea of a research or mention in your existing research on the economics of the drafting of the judgment in itself, on how the judges come across and give that particular amount and how they, make those calculations, and how that can be integrated with the world economic system as such. Perhaps if there was something there, or you would like to take it forward, please go ahead. And then the next question is for Professor Bhumika Nanda. Ma'am, you had mentioned I think this was not the main focus of your paper by title, but when you talked about Jus Muniendi, and then how you mentioned that ICC is a giant without arms or legs because it did not really have a lot of definitions. So I wanted to ask if the fact that there were conventions on genocide, and then the 4 Geneva Conventions and the additional protocols, and now even the ILC is contemplating a convention on the crimes against humanity. It's a convention. So when these already exist, do we really need ICC to also come up with its own set of definitions? Does the giant need its own arms, or is it fine hanging on to the broader conventions which have established jurisprudence? Thank you.
Yes, thank you so much for your question. So, yeah, it's how to make calculations. So, rules 94 to 98, those rules we are required to refer, and you will find that annexures are also there along with the rules. Means the structure of entire Rome Statute is Rome Statute, then rules, and then all the annexures are there. In this annexure, you will find the annexure is there wherein so the process is ICC take up the situation. Then under trust fund, simultaneously they will call upon the applications from the victims as well. And then victims are required to fill those applications. In those applications, they are required to prove that they are belonging to that particular situation. So their name, address, evidences, supporting evidences, and then damages which they have faced because of that particular situation. So that also they are required to list down. Now, once they will list down, then after that there is a procedure about inquiry and investigation, that how far it is correct, because as you know that many people, they might misuse it also. So investigation is also taking place, and then as per the investigation, then they come out, the investigation agency, they will come out with the entire report. And in that report, then they will mention that per victim, how far the damages are there or the loss is there. And then accordingly, they come up with that particular amount, and all that report they are required to submit to the judges of International Criminal Court. And then based on that, then they come up on this particular amount. So complete economics is there when they are giving all the amount. So even though it is 52 millions, why? Because in Ogwen's case, it is 52 million. Because in that they have identified around 50,000 victims. So therefore 50,000 victims and 52 millions. And plus they have given the individual reparation and collective reparation as well. That is community based reparation also. So therefore, in all, if you will see the situation, you may find that amount is, we can justify the amount. But then the question is how you will be able to pay it. So ultimately, if nothing will be paid, then in that case, what is the use of giving such a hefty amount in reparation? Yes. Thank you.
Thank you for your question. So, 2 parts. I'll answer in 2 parts. One is that ICC has its set of definitions. ICC, being a criminal court, has to follow the statute and the rules of evidence and procedure which is being given there. Just one thing which they have done is that within the ICC statute, when you talk about the sources of International Criminal Court, they are bound by their own statute and the rules of evidence. Plus, they also are allowed to take references from the other international conventions, and even from if it is required, from the human rights principles. So I read Article 21.3. It says that whenever the ICC judges are giving the judgment, it has to be in conference with the other international law, human rights principles, and making sure that they are not doing any distinction between gender and those kind of discrimination. So it has in that sense, it is not without legs and arms. So it has its own core statute. And if it come out with crimes against humanity, different convention on that, the only plus point is that states who may not want to become a party to ICC, because it has other kind of a supra power and they can be included, can at least join, and sign and ratified crime against humanity convention. So that is plus point. That's what genocide convention also happens. So India is a party to genocide convention, though we are not a party to ICC. So we still can't go against those basic principle of genocide. So that's one thing. In a way, I think that crime against humanity in any way should form part of just cogent. So you don't need it, but still, if you're going forward with the convention, it's okay, plus point added to it. Now, without arms and legs concept is with regard to the enforcement mechanism which ICC has. So you created a huge mammoth structure, but how will it get its judgments and everything enforced? So the other presenter gave the example that they issued the arrest warrant against Omar al-Bashir. The other states who are party to the ICC are not adhering or enforcing that arrest warrant. So that way, they don't have arms, they don't have a police mechanism which we have it in a national level. That where it is losing it. The other point is that, okay, they created that they have a jurisdiction, but then they also allowed states to enter into bilateral treaties with the other countries. So USA is one of them, entering into bilateral treaty with all those countries where the peacekeeping forces or their members are part of the peacekeeping forces and getting immunity from that so far as ICC is concerned. So they have to send them back to US. Can't refer them or send them to the ICC jurisdiction. That's where the ICC is lacking it. So it's a great structure, but the implementation is kind of being pulled, restricted from various corners, including the finances which has been given to ICC. It's by the Assembly of State Parties, where all the UN members, these parties are also part of it. So you are not a signatory and ratified to the ICC, but you are pulling in the money. So that's where they are trying to make sure that it still doesn't function as that much independent as they envisage it to be. So that, I hope it clarifies. Thank you.
I also have a question to Bhumika. My name is Safif. I'm an LLM student at South Asian University. So you were talking about feminist approach. My question is, how does this feminist approach has an impact on the principle of complementarity? Because as far as the ICC is concerned, it works on the principle of complementarity unless and until if a national prosecution is happening, if there are certain criteria mentioned under Article 17, then only the ICC can come into play. So my question is, if a national legal system, if a national criminal law is inherently discriminatory based on gender, but still they have conducted a prosecution and they have conducted a trial of an international crime, assuming that, how does ICC look into this scenario?
I don't have case in my head right now, but the thing is, the complementarity says that the national system should be genuinely able to deal with that case. So when the word genuine comes, they say that then it is a responsibility of the ICC actually and the prosecutor and their team to see that the national system, which is saying that okay, we are capable and willing to deal and prosecute them, had that national laws in place which are neutral, which are not biased towards one side. So that is a responsibility. So you can't have a complementarity being given to a national level and then forget about it, because that entire complementarity, as I stated, requires these requirements of genuineness to be there. So if my law, for example, many of the countries who are following a restrictive and orthodox laws are very clear that they do not consider these kind of offenses to be the offenses, and then they are ready to prosecute it. So what will happen is that they'll do a sham kind of a prosecution and will not have that recognition to be given to the victims which they seek from any criminal court, be it a national or international. So ICC technically in that context should not consider it to be a proper prosecution done or conducted by the national level authorities. There have been examples, I'm not able to recall it, where they have actually questioned the genuineness of those national courts and said that okay, this is not proper and we can't consider the prosecution to be done, and the prosecutor tried to refer it back again to the ICC.
But after connecting this thing to that, but I'm a bit skeptical about that fact, how this standard can be brought in under Article 17, because and how you mentioned about the inability and to prosecute and unwillingness. So how this gender aspect can be brought in to Article 17. So are you saying that, but this aspect has been mentioned under Article 21, applicable law?
Exactly. That is sources.
So are you saying that while deciding a case based on complementarity, ICC has to resort to the applicable law standards under Article 21?
They should. So what happened is that if you look at normal VCLT conventions and treaties also, once we ratify and convention, we have to make sure that our domestic laws are also in line with it. So I can't have a domestic law which is in contradiction to what the international law is telling. So that shows. So international law, so far as international forum is concerned, is more it has to be given that supreme kind of authority. So I need to tweak my domestic laws in line with the international criminal Rome Statute if I'm a party to the Rome Statute. If I don't do that, then there is a huge gap between what the national law is saying and what the ICC is telling. So what happened? Anyways, there is again, and I think is ICC only deals with the major criminals. The top cream goes to the ICC. The rest are being taken care by the national level courts only. So that's, you can't have then two double standards being applied in their own country and other. And that's where the feminists who are writing on this thing and which I'm reading it are questioning it, that we are not happy with the way the national levels are doing it or even the ICC is doing it. So what they started doing it, they started forming their own hearings, which does not have any effective, but it has that concept of giving them that recognition that okay, this happened with us and now it has been recognized and we are able to speak out and tell about it. So those hearings has happened at different places. I got the example of Brussels, it has happened, then East Timor also they have taken it up, and I think one more place, I'm forgetting the name. So they're just hearings. So sometimes victim may not want the prosecution of the person to be done, but what they want is that their whatever trauma they have gone through, they'll be able to share it out and kind of explain it. So according to me, if it is not done by the national authorities, then they're not adhering to the convention entirely.
Actually, I have a lot of doubts on that, but we'll talk later.
Okay. I'm also working on this point.
Question, when you talked about this victim participation, don't you?
Yeah, please.
One second, with the permission of the chair, I want to add what Bhumika is saying. Actually, one more thing which we are required to refer, that is the definitions of crimes which is given in the Rome Statute. Okay, so if you will see the definitions which are given, like what do you mean by war crimes, genocide, crimes against humanity, etc. So we are required to read Article 21 along with this Article 5, 6, 7, 8. And then we are required to see about your question about, in the principle of complementarity, how far you are taking care of, gender specific crimes and how you are responding towards the same. So this is, in combination with all these articles, then we are required to see. Now the situation which Dr. Bhumika, she is also giving as an example, that
no, I was
if
not
the
mentioning
national laws,
gender-specified crimes. I was
but feminist approach you wanted to
how
highlight.
do we bring in that concept?
So
into
if your
principle of
national laws are speaking different, as she is saying, that once you are ratifying, so obviously you are required to incorporate. And what they will incorporate, of course, sources and plus all the definitions also which are given under ICC statute. Right.
another. Oh.
Good morning, all. I'm Dr. Kanika, Assistant Professor, Indian Society of International Law. So I have a question addressed to Himanshu. You have mentioned genocide, but I want to know about genocide in Indian context, because India is not recognizing genocide till now in context of Kashmiri Pandits. As even after 35 years of struggle, they are still struggling for crime against them, which is genocide, as Indian government is not recognizing crime as genocide against them. Plus, they are still struggling for their status also as IDPs, because they are not been given the status of internally displaced persons, still considering migrants here. So, if you have any observation on why they are not, the crime against them is not recognized as genocide. Thank you.
As far as my reading goes, ma'am, there are the crime of genocide is not embodied either in the Indian Penal Code 1860 or even in the new PNS 2023.
India has ratified genocide
Yes, ma'am,
convention.
India has ratified the genocide convention. but then it has not made its laws in consonance with the Genocide Convention. So we don't have genocide per se as a punishable crime in the Indian criminal jurisprudence. But as I said about Jonah Raja, he was giving the concept of genocide way back in the 15th century, and at that time also Kashmiri Pandit genocide took place. So what he was calling is that he was calling that as a genocide, and which took place in 1990s again on the same line. So going by that definition, which again is very similar to the definition under the Genocide Convention as well. So it can be called as a genocide, but then given the fact that India as a national jurisdiction has not been able to recognize it, and then again at the level of international law, given that there is a lack of a centralizing authority in international law from which laws permeate to the national level, or which can essentially declare that yes, this was a genocide or not. So that is a very challenging task. And it is that's why that it is ultimately the international courts which are called upon to decide whether a particular act is a genocide or not, because UN somehow gets into the political sphere, and although given the fact that courts also work in an uncompromising political environment, and that is why Alexander Bickel has called what is known as passive virtues. So courts also abstain from deciding certain cases when the legitimacy of that courts are into question. So that is what the courts have been doing. In fact, this whole notion of courts coming up and holding a particular criminal activity as a genocide will take time. So again, the matters are up before the ICJ right now. So some 3 cases of genocide are being taken up by ICJ, particularly Gambia versus Myanmar, and South Africa versus Israel, and Russia-Ukraine war. So it is a third case study through which courts can evolve the jurisprudence of genocide and declare stricto sensu that these are classic cases of genocide. So that is the reason I see. So they have been exercising that passive virtues by now, and maybe now is the right time for them to take that lead and hold that yes, these activities are genocide. Yeah, thank you.
I have a question addressed to what is the success rate of this trust fund? Because the countries involved in this issue they are all poor people. They are poor countries. So I know that, and I am sure that rich countries would not contribute to trust fund as well. So where do they get fund, and are they successful in that?
No, rich countries, they are contributing towards trust fund, and they are giving a lot of aid also. Now it is a topic of research. Actually, I wanted to do, but because of lack of time, I have not done it. So you will find that if I am not wrong, in Congo they have contributed more
Yes.
in comparison to Uganda. Okay, so but however, the rich countries, they are giving funds, and trust fund, actually they are just collecting money. This is how they are raising their fund also.
Even the US and Russia.
US. So rich countries means, actually I wanted to say that US is funding.
They are contributing.
Yes,
to
they are
reparation.
contributing. Yes, they are contributing. But it's not about reparation. Actually, that is also one thing. In trust fund, it is a common pool wherein they are just getting all these funds. Now, however, as far as whatever research I have done, they are calling for funds or requesting for funds for a particular situation. So now again, it is also required to be researched that when they are pooling money, is it so that it is a common pool? So there is a common pool. But in addition to this, they are requesting for specific situations also. And the countries, they are coming forward for a specific situation as well. There are 3 types of work of assistance which is coming under the mandate of trust fund as per the Rome Statute and as per the rules. And in that, one is like whatever the destruction has been done of the property or so that is a reconstruction, one thing. Then regarding the psychological help is also there. It is also coming up. And one is individual centric, like victim centric allocation of fund is also there. So these 3 things are there which is coming under trust fund. So again, whether they are getting the fund only for one specific thing or all of 3. So whenever the one is giving the fund, they are also required to give the explanation that where they wanted to utilize that particular fund through the trust fund. But yes, they are contributing.
I have one more question to Professor Rashmi. So when we talk,
Let us figure out if there is someone else also who wants to ask a question. Maybe over a cup of tea, you can have that volley of questions and answers and clarifications. Yes, anyone else, please? And if anyone else doesn't have any query, then maybe you can utilize the floor before I give my observations. Anyone else?
when we talk
Okay.
about the victims' participation, it's a very peculiar thing to ICC. It's not a very common thing to most of the criminal jurisdictions. So it's a criminal code. So don't you think that this victim participation itself causes prejudice against the accused, because it's already happening in a very precarious political situation. So will it cause setting up a narrative against the accused which is prejudicial to him during the proceedings?
I don't think so that some prejudice will be there, because it is the victims, they have that particular feature, so therefore they will give their narratives. Then again, it is the rights of accused are also being protected under Rome Statute. So he may say or she may say that he is not involved in this particular act also. So because it is like one is the perpetrator and other person is the victim. These are the two main parties actually. So therefore, according to me, it is not about prejudice. But yes, as I've told in the beginning of my presentation, victim participation is itself a complete area to research. Thank you.
Thank you.
Okay, that takes us to the last part of this session. And if there is no other question, couple of observations. Because anybody who has done a research and presented a paper has done an in-depth study in their respective areas, a different perspective or maybe something that can be added on. I'll just point couple of concerns that occurred to me while I was listening to your presentations. First of all, congratulations to each one of you, and I'm happy to state that they were well researched, focused papers, wherein each one of them tried to get into the details of the working of the ICC. Now, going sequentially first to Professor Rashmi Salpekar, you did talk about reparation. That took me straight over to 1985, Vienna Declaration on the Rights of the Victim. So I was just wondering if, and I was certainly keen on looking into the philosophical distinctions between, say, compensation, reparation, assistance, and restitution. And if we get into the details of that particular declaration, we find that it recognizes victims on a very large base, so that it is not restricted to like your genocide convention on those 4-5 parameters. So that takes into account emotional aspect also. So that I was just wondering if we can, or maybe you can in your future write-ups somewhere try to philosophically, jurisprudentially highlight that when we are talking about reparation in international law and specifically with reference to ICC, how is it similar or different to the concept of restitution or assistance, and what all can be brought in when we are talking about reparation? What is the purpose of reparation? Is, you yourself said that ICC is, the mandate is not to be punitive. But when we are saying it is not to be punitive, and then simultaneously we are also highlighting the fact that it is compensation to this huge amount, wherein we just discussed that TVF may not be the trust fund from where the corpus comes in. So when we are talking about that restitution and on an international platform, we necessarily have to have that much of corpus and money. So if it is seriously talking about assistance or reparation, should we have some methodology or procedure to mandate and dictate that, say, if there is a fund being, say, contributed for a specific purpose, it gets utilized in that. So how do we channel that? And if it is a common pool, how do we segregate, on what basis we demarcate that which quantum, what quantum would be the most appropriate, wherein Walter also talked about the economics of the judgment, that how much, when you're talking about millions, on what basis, 50,000 people and 52 million, on what basis, though you did reflect on that. My concern is that would it be and should it be left to the discretion of the judges on the panel to decide as to, and then each one of us has got our own biases and baggages. So should there be some streamlining of the process, that how do we ultimately come down to the value of reparation? That is another aspect that I wanted you to highlight. And the last point that I certainly wanted to point out is that when we say ICC is primarily for natural persons, and we are talking about victims as both natural and non and natural, that means juridical. How do you reconcile that? How does one reconcile that there are two different aspects when we are talking about, and then you said rehabilitation, medical support. So when we are talking about any institution, these are meaningless when we talk about medical support. And then it comes down to only monetary compensation. What is the reason that when we are talking about victim, we are including juridical persons also, but when we are saying ICC, we are only focusing on a natural human being? So is there a process of reconciliation wherein the ICC jurisdiction also is being widened, or should there be some talks on that count? Please.
Thank you so much. So, as I have mentioned in my presentation, Rule 85A and B. So, they have defined about victims, and if we will go for their draft article also, so it is based on 1985 victim related declaration. So the definition of victims, which has been given under 1985, so earlier they wanted to have the same, but then later on they have come up on this Rule 85A and B. But then the philosophy is the same, which has been also mentioned also, means they have recorded it as well. Regarding the natural person, so actually the mandate of ICC is to prosecute natural person. So thereby Article 1, they have referred about the natural person that they can prosecute. But regarding victims, now why is it so that in 85A they have mentioned about the individual person who is a victim, natural person, and B is about the organization? Because while giving reparation, what they wanted to give that whatever the harm has been committed, so that harm is required to be compensated. And if we will see the definitions of all the crimes, like crimes against humanity and war crimes, etc. So under war crimes also, they have incorporated even the cultural monuments as well. So if there is destruction of some cultural monuments, like in one of the case, yes, so in that also the compensation has been given. So thus, unless they will not add the organizations or the cultural monuments also, whatever harm has been done, so how you will be able to compensate for those kind of property? So therefore, under victim, they have covered both, that is natural person and also the cultural property, organization, etc. So it is only to see that yes, these situations may also come. So to execute in true sense the definitions given under war crime also, this provision is there. So therefore those two things are there. Now regarding how the medical support and etc. is relevant for cultural monuments also, so of course not. So they have given only these types or these options. So like for natural persons also, the medical support and psychological support is there. Like in the case of Thomas Lubanga, a lot of emotional support has been given to the child soldiers and their families. And two types of victims they have identified under natural person also, that is direct and indirect. Direct means those who are actual victims, and indirect means their family members and locality people also, but not locality, but mainly family members and relatives, which they have said. So therefore, even though the list is there, like compensation is there and monetary benefit they are calling it, and medical support also, but it is depending that who is coming before them as a victim. And reparation, this is the term which they have used collectively for all the types, including compensation, restitution, rehabilitation, and other things. But the umbrella term which is used under Article 75 is reparation. So when Article 75 is giving that, saying that reparation is to be given to the victims, herein in victims they have taken care of 1985 declaration along with the rules. And when they are saying reparation, it means that all types, including monetary benefit, restitution, rehabilitation, etc. Thank you.
Thank you very much on that response. I'm just wondering that if we are so concerned about collectivity and giving reparation to juridical persons, where is the harm in widening the scope of ICC, not just humankind, but even juridical persons? Maybe we carry on that conversation a little later.
Yeah, sure.
Yeah. The second speaker, Shubhamanyu Lahide, you did talk about the referral and deferral powers of the court, and essentially highlighted that despite the fact that there is that referral power, even deferral powers are there. Referral powers may certainly be circumvented. So, what is the way forward? Can you just think aloud that finding out these gaps, these difficulties, if we are talking about strengthening international law system with reference to crimes, war crimes specifically, and more so in the current geopolitical scenario wherein everywhere we find that there is a front coming up and there are wars happening and situations are escalating, how do we resolve it? That it's not that the powerful on the global scale and global platform and UNSC are able to dictate terms.
Should I? Okay.
Please.
Thank you for your comment. So that is actually the original idea of the manuscript, which I actually could not give here because there's another professor who's working with me. So we're focusing on these solutions as to the reform of ICC to make it more global, to make it more approachable. So of the multiple kind of suggestions that we've received, that we've worked on, two in particular have caught my mind. I would say three technically. So, but then again, as I stated during my presentation, all of them are very idealistic in nature, but we are still working on it because these are plausible ideas that, if not today, probably 50 years down the line, would be possible. So, one of them is through an amendment to the Rome Statute, shifting the referral powers from the Security Council to the General Assembly, because one, the General Assembly does not have veto power. Two, it is a larger body compared to a 15-member council, and the General Assembly is more generic in nature, so which allows them to also focus on security-related matters, because in the past they have released security-based resolution, which there was a time was supposed to be the exclusive work of the Security Council. So if that referral power actually goes to the General Assembly, we would see more cases in the court. We would see more equitable cases in the court. There would be no such shouts of bias because the countries that are actually getting referred to are present there and are referring other countries as well. Because that actually came out as an issue, especially during the 94 Rwanda genocide case, wherein Rwanda was actually part of the Security Council when its resolution confirming the ICTR was passed, and Rwanda actually objected to it. But it fell on deaf ears eventually, and rightfully so, as we saw the work of the ICTR. So one is that. The second is, and it's probably one I am personally more inclined to, is the regionalization of the ICC by allowing supranational regional institutions such as, let's say, a European Union or an African Union or an organization of American states to refer cases to the same. Now, we had received questions as to what qualifies as a supranational institution, why would only they have such powers and not other organizations? To which our answer is, one, we cannot give that power to, let's say, individuals or NGOs, or for that matter other institutions, because one, that would overload the working of the ICC. There would be a lot of cases, and we've seen in the Indian courts as well, pending cases are not something we like, do we? Um, but since we've seen how centralized the court and as how rigid the court is, we would like a bit of regionalization. So giving these powers to such supranational organizations is a good thing. However, on that I would like to point out that the court is largely disconnected to the Asian subcontinent, I would say, because we've seen India, Pakistan, China, or if you go up Russia, even a lot of the Southeast Asian nations, they're not necessarily a party to the Rome Statute. They're not very active in such proceedings, right? So, if probably in that sense we could, and that would be a problem even with a supranational institution, because there is no Asian Parliament, there is no Asian Council of Ministers like we have in Europe and Africa. So that is also something we're working on. And the third is the same principle, but instead of an amendment, because we also realize that amending the Rome Statute is hard. We saw that in the Kuala Lumpur conference. We saw what happened with the crime of aggression as what was added in the Rome Statute. And again, this is an idea out of the box, probably very impractical as well. But probably seeing this kind of a regional institution affiliation as an extension of Article 13A and Article 14, which is state party reference, because these states are a part of the supranational institutions, and these supranational institutions consist of states and members of these states making these decisions. So that those were three prominent reforms that we have thought of. We're obviously open to any more suggestions that could come. We'll gladly take it, and if you do, please feel free to.
Thank you, Shubhamanyu. That takes me over to Bhumika. Bhumika, your topic, feminist engagement and inquiry into the working of the International Criminal Court, wherein you did mention about peace versus justice dilemmas. I was just keen on understanding that the moment you say feminist engagement, and you said that reading between the lines, to me it appeared to be, sorry to use that word, a little biased to begin with. Because is it that we are saying that women alone need to read in between, or they have the capability to read in between? And because they have that capability to read in between, that's where we need to have more women on board. So should we not instead be talking about that we need to think the way things have to be thought about and read about? So reading in between the lines is not primarily the domain of women as such. We can understand that they've got more psychological, emotional power, and they are much more having capacity to deal with critical situations. And when we are talking about war crimes specifically, yes, we are talking about critical situations. So when we say feminist engagement, what is feminist when we are talking about maybe the crimes of genocide, or for that matter, when we are saying that we would recognize crimes of humanity? How is it that feminist engagement would be much better in ultimately giving the resolution to the issues that we are addressing right now? So from which standpoint we are talking about feminist? Please.
Thank you, ma'am. Ma'am, feminist engagement, when I'm using it, I'm not using to say that only woman has to be the kind of flag holder so far as these judgments are concerned. It is spoken in the context that when any crime which is being there, they don't see it from the orthodox manner which we have looked into. They also see the context in which that particular crime has happened and whether it is going to reach that particular justice they're doing it. And that can be done by men and women both. So women, in fact, are not the flag bearer of that. Just that, so that is what ICC also does, that it wants to show the gender is being equally done. So they allow for male and female to be done in that particular, judges to be appointed in that. But what it does is that another second level is that they say that they should also have the expertise in the child and women violence related cases. So it could be a man also who has sat or who had the experience in dealing with the violence issues regarding children and women, and that person can also give a very proper judgments. So the feminist engagement is only made in reference to, so to look, to ask the woman question, not, or to ask a gender question, to be go into more, instead of not looking into women also, but also to look into gender, to have a male concept also, is asking those questions, seeing that as to the interpretation is not done in a very rigid manner. The interpretation of a clauses is done in a manner where they adhere to the secular. So what happened in one of the case which is pending before the court and is will be heard in December, they're looking at violences which is done against men so far as sexual violence is concerned, and see whether those sexual violence cases again men can also be recognized. So so the moment I say feminist is not woman.
Bhumika, I understood that
but
very
it's,
clearly, having our, say, relating back to our earlier days.
Yes.
And somewhere I wanted to take you that when you are making a presentation and you are putting across a statement that women have the capacity to read in between the lines, and if we contextualize that statement
It
in the
can
backdrop
be
of the
embarrassed.
title, it can be understood differently. Now you have put the things in perspective.
I'll rework on it. And then on the bias
and
thing, actually,
clarity.
if I say that, so what happened, dissenting opinion of Lubanga, that was a female judge who said that we should read sexual violence against children also in it. And same criticism came. You're biased, you're woman, you're biased because you're dealing with the sexual violence. So I can,
And your
rephrase it
penalties made
properly.
statement wherein you inform us that there is a case with reference to sexual violence against a male that sets the things straight, that we are not only talking about gender in the context of women alone, we are also thinking on the lines of and considering, despite the fact that in our Indian jurisdiction, unlike crime of genocide and internally displaced people, we are having cases wherein sexual offenses against men are also being looked into. That is certainly something that we need to bring into our Indian jurisdiction also. So that was just one aspect. And when we talk about feminism, there are a lot many theories to talk about, and I was just thinking that perhaps you would somewhere take that from this perspective we are talking about feminist engagement. That would make it more holistic.
I'll include that in my paper, ma'am.
Himanshu, to you, certain observations. You did talk about historical development and evolution in your abstract. You talked about Pandit Juna Raja from the 15th century, I believe. I was keen to learn if there are others also before him or post him who have also thought about and talked about genocide. That would make the entire presentation more wholesome the moment you are saying evolution and history. So it's not just one out there, somewhere in oblivion as of now, not recognized, not known, and we are saying that from him perhaps Raphael got his inspiration. So if we as such as Indians do not know who he happens to be, how could Raphael get to know? So if there is any connecting link, any information, any resource wherein it states that yes, he had read this from this particular gentleman, as you stated, Juna Raja, that would be great contribution in reviving and revitalizing our own Indian roots. And I'm happy that you are into digging into your own cultural heritage to understand that is it that whatever we are talking and thinking about and researching is Western, that we are trying to bring in because that is more advanced, that is much more knowledgeable, and we need to learn from them. Certainly, we need to learn best practices from them, but whatever is good with us, we perhaps were on a better platform and better understanding. So, please dig more into it and figure out as to what we are, what all others are also stating, because whenever we are talking about any practice, that has got a context and substratum. So around that era, there would certainly be some others, may not be many, but some others who have talked about, or someone else also from 15th to say 21st century talking about, someone would certainly be there. Another aspect that Kanika already highlighted, We are talking a lot on the international platform and talking about international law. What about our national laws to be brought in consonance with all these crimes that we are recognizing on an international platform and international laws? Those soft laws are talking about genocide. And despite the fact that, as rightly stated earlier, that we had the IPC, perhaps the colonial law, but now that we have got our Indian law, are we still not acknowledging and not prepared to face the fact that people, not only in Kashmir, you talk about Northeast, you talk about all these areas of conflict wherein we find that people are being massacred purely on account of their ethnicity. So, and if that is recognized as such in the crime of genocide convention, what prevents the state, the Indian state, from recognizing these at least within its own jurisdiction? So, can you suggest and come up with a working paper wherein you are suggesting that this is the need of the hour, we need to recognize? So, towards the end, let me just highlight myself being a Kashmiri, have a weak and soft point on that. And I'm certainly bothered that we do talk about genocide across the globe, but we do not look back in our backyard as to what is happening. So, until and unless we do something with reference to our own people on the lines of international law, we are failing our own population, and we cannot then have the flag and be the torch bearers of human rights. So, this is something which is minimally required and expected of our own Indian government. So, on that count, that anyway, certain those were my sentiments and emotions. Would certainly look forward to your contribution in suggesting and recommending to the state that please be through with this stage of slumber and sleep, get out of it and do something. There, it's not that it is not within the knowledge of the state. There have been petitions filed, and the state has differentially conducted itself. If we are talking about 1984, Sikh rights, they are being recognized. The killings are being recognized. But 5 years down the line, 1989 and 1990, ethnic cleansing. Here it was a case, not that I have disrespect or I do not recognize the atrocities conducted and committed against the Sikh population. But at the same time, if we go by the proportionality, the entire race was driven out of their native land. And 3,005 lakh people, even if we go by the pure governmental statistics, which I personally am not prepared to accept. So, can we have a comparison that with reference to 3,000 people of 1984, the Supreme Court was open to entertain their petition and challenge and thought about them. But with reference to 1990, 6 years down the line, 5 lakh people right out there in front of their eyes, they are not believing and they are not doing anything on that. So I would certainly look forward to listening or maybe reading something on that. And by this time, I also have got this time's up. So thank you very much for bearing with those comments. Thank you.
With that, we come to the end of the first session at Maple Hall on War Crimes and International Criminal Court. I thank all the panelists for their wonderful insights, and I thank the chair of the session, Professor Anju Wali Tikku, for wonderfully orchestrating this session. Now I request Professor Banerjee Cheka to felicitate her. Thank you, sir. Thank you, ma'am. I request all. Is not joining us? Okay.
But some names were online, maybe you could put those names here.
Only these two.
Say that they are online.
I request all the panelists and the chair to be seated at the dais. Share this. Share this. Is Adnan present online? No, he's not joining us. Mhm. I request all the panelists to be seated at the dais, please.
You can sit here if you want. Yeah, you can sit here. Yeah, of course. No, it's fine, it's fine. You can sit here. So you can click the pictures. You can click the pictures also.
Is it good spot?
Katrina. Coffee? Slow down, caffeine intake.
Jamshed Ahmad Siddiqui and Adnan Asrar, are they present in this hall? Please be seated. Is Adnan Asrar available online?
Online speakers
Online presenters are Good morning, everyone. We'll start our next session on international law. This session is chaired by Ambassador Narendra Singh, Secretary General, Indian Society of International Law. Ambassador Narendra Singh is a distinguished figure in international law, recognized with the 2017 MC Bassioni Justice Award for his impactful contributions to the field. Throughout a career spanning over 4 decades, he has shaped India's engagements with international law, most notably during his tenure as legal advisor to India's Ministry of External Affairs. Ambassador Singh played a vital role in significant international negotiations, represented India in numerous UN bodies, and participated in important arbitration cases. His expertise was further acknowledged through his decade-long membership with the International Law Commission, where he chaired the 67th annual session and actively contributed to the Commission's work on immunity of state officials, environmental protection in armed conflict, and on crimes against humanity. Ambassador Singh has also been dedicated to mentoring young professionals, particularly through his leadership roles in the Indian Society of International Law, where he also helped expand the access to the Society's journal. His commitment to promoting international law education has made him a key influence in developing a new generation of Indian lawyers in the field of international law. His work has extended to supporting historical legal documentation, notably contributing to projects led by the Center for International Law Research and Policy, reinforcing his legacy as a mentor and leader in international law and justice. He is currently serving as the Secretary General of the Indian Society of International Law. Over to you, sir.
Thank you, and I welcome all the panelists and also all the participants here in this session on general international law. Today, in this session, we have a number of online panelists. I see that two of our online speakers, Professor Mirko Sosai from the Roma Tre University, and Professor Alice D. Jonge from the Monash Business School, have already joined us online, and we welcome them to this session and to the conference of the Indian Society of International Law. We are waiting for Professor Pavel Sturma to join us from Prague, and I hope he will be joining soon. Well, this session was to be chaired by Dr. P.S. Rao, who was the former head of the Legal and Treaties Division. He served for a very long time as head of the division. He was a member of the International Law Commission for 4 terms and was also chairman of the commission, and he also served as an ad hoc judge in the International Court of Justice, as well as an arbitrator in the maritime boundary arbitration between India and Bangladesh. Unfortunately, he is not well and cannot join us here today. Otherwise, it would have been a real treat to listen to him. Now, but we have to make do with a very poor replacement for him. So now, the development of international law has progressed very rapidly after the establishment of the United Nations, because firstly, the UN Charter has given a mandate to the General Assembly to work for the development and codification of international law, which it does firstly through the International Law Commission, of which I had the privilege to be a member, and also through general codification conferences and other procedures. And during the period following the establishment of the UN, a large number of conventions, lawmaking conventions, have been adopted through the United Nations. And one of the issues which we were going to discuss, which Professor Pavel Sturma was to take up, is the principle of the rule of law. Because while it is important to adopt conventions and codify rules of law, we also need to see that these rules are applied uniformly. They are applied with the proper balance between the smaller and larger states, and in a sense that the rule of law is being maintained in international relations. So we'll wait for Professor Pavel Sturma to join us, and meanwhile we'll go to our first online speaker, Professor Mirko Sosai at the Roma Tre University, and he will speak on the potentials and pitfalls of the increasingly evident impact that urbanization has on the development of international law across different regions of the world. We look forward to his very insightful comments on this issue because, as you're aware, over the last century, the world's population has grown over 4 times. 100 years ago, we reached 2 billion, and now the world's population is more than 8 billion. And the impact this has on urbanization, especially on finding housing for all these people, the impact it has on diversion of forest lands and agricultural lands towards housing and other needs. I think we will hear from Professor Sosai on the impact. You have the floor, Professor. We don't have the sound.
First of all,
Yeah, now we have. Thank you. We can now hear you.
okay, good morning from Italy. First of all, thank you, Mr. Chairman, for the introduction. I'm very honored to take part into this very important international conference on the Indian. And as you mentioned, I would like to speak on an important development that has been quietly transforming the practice of international law, the rising role of cities and their networks. As Mr. Chairman mentioned, we are indeed living in an era of rapid and unprecedented urbanization. More than half of the global population resides in cities, and this number is expected to rise significantly in the coming decades. The urban centers face critical challenges, ensuring access to adequate housing, mitigating urban poverty, delivering essential services, and maintaining a healthy environment. Moreover, new digital infrastructures and surveillance technology are reshaping our urban spaces at a global scale. And the recent news from Middle East confirm that urbanization of warfare poses significant challenges to the application of international humanitarian law. And this trend has led to complex difficulties in protecting civilians, distinguishing combatants from non-combatants, and minimizing harm to critical infrastructure. Despite this profound transformation, cities have historically been seen as marginal to international governance, and their role often invisible from the viewpoint of international law. But over the past few decades, cities have become increasingly involved in issues that transcend the national borders: climate change, human rights, migration. While international law has traditionally been the domain of states, cities have found themselves filling governance gaps and stepping up where national governments has failed to act. This development is not just a political shift, but has real implication as for the practice and evolution of international law itself. Of course, I cannot provide in my presentation today an exhaustive overview of all the ways cities are impacting international law, but I would like to focus nonetheless to some key areas where this shift is more visible. First of all, let me begin with climate change, one of the most pressing global issues of our time. Cities have been at the forefront of climate action, forming global networks such as the Local Governments for Sustainability and the C40 Climate Leadership Group. These networks represent cities that have stepped in to address governance void left by the lack of robust action at the interstate level, particularly during the uncertain years following the Kyoto Protocol. Where national governments stalled, cities acted. Through these networks, cities have been able to share best practices, influence climate policies, and push for more ambitious environmental goals. Although cities may not have the power to create binding international law, their collective actions have shaped the practice of international law in the environmental area. The second area, of course, is the field of human rights. In some cases, cities have gone beyond merely implementing their state's human rights obligation. They have chosen to take matters into their own hands, integrating international human rights standards into their own policies, and in some cases compensating for a lack of action by national governments. Migration, that is my last area for this very brief overview. The field of international migration law has also illustrated so far the bold role cities are playing. In many cases, cities have taken action that defy national governments' policies. Some have declared themselves sanctuary cities. Others have joined the networks of cities of refuge, offering protection and assistance to vulnerable populations. Once again, these practices do not fit neatly into the existing legal categories of international law, yet at the same time, cities are contributing to the renegotiation of international legal norms, particularly around the protection of migrants' rights. For instance, in the Netherlands, legal disputes between national and city governments have led to the clarifications on the standards for the protecting the social, cultural, and economic rights of irregular migrants. Cities have taken on more global responsibilities. International legal scholarship has gradually begun to acknowledge this trend. Early pioneers in this field observed how local governments were becoming more and more involved in international governance. However, not all scholars are entirely convinced. Some, like Giuseppe Nesi, the current Italian member of the International Law Commissions, remain cautious, questioning whether cities can or should be considered subjects of international law. Nesi has reminded us that cities remain somehow peripheral to the formal doctrinal categories of international law, particularly when it comes to questions of not only of subjectivity, but also on responsibility issues. Despite this reservation, the growing role of cities cannot be denied. We are not actually witnessing the displacement of the state as a central actor in international law, but new actors, including cities, contribute to lawmaking processes through the participation in international conferences, to lobbying activities, and to forms of cooperation that once were the exclusive domain of cities and international organizations. So, as international legal scholars, I believe, also as a co-rapporteur of the ILA Committee on Urbanization and International Law, that we international lawyers must remain attuned to these developments. International law is a social medium that both enables and constrains the exercise of powers. If cities are increasingly engaging in international activities and influencing the interstate system of international law, this is something that we need to account for and scrutinize. The rise of cities in global governance might represent a form of what Janet Leavitt has called bottom-up lawmaking, a process where non-state actors like cities contribute to the international legal developments from the ground up. In response to this emerging need, the ILA Committee on Urbanization and International Law has started to collect key questions concerning these possible developments for future, and in this respect also possibilities to open up new research areas. In this respect, urbanization holds both potential and pitfalls for international law. Cities may serve as crucial sites for addressing pressing global governance issues, but on the other hand, the direct interactions between the global and the local can also expose vulnerabilities in urban governance, particularly in the context of power imbalances that may disadvantage local governments and their citizens. I would like to conclude my presentation today to pose some questions also to the audience. How is international law evolving through the urban context? How does urbanization shape the implementation of international law in specific thematic areas? How is urbanization affecting international organizations in their processes for implementing law and policies? How urban voices are represented in this international arena? And how do cities seek greater representation? What is the role of city governments as non-state actors? What are the implications of transnational financial and technological flows, particularly in the areas of climate actions, energy transitions, and the development of smart cities? How about the accountability of cities in the context of international law? And what is the impact of urban warfare, and particularly what could be a urban diplomacy in this field. And finally, since we mentioned since the very beginning the role of the International Law Commission in the development of international law, what is the impact of these developments with respect to a brand new topic that the International Law Commission started to investigate, that of non-binding international agreements, and the growing role and participation of cities in these processes? How does this trend influence the involvement of cities in global governments, and what are the further implications for international law? These are just a few of the many areas that we hope to explore in greater depth. I think that there is also need to gathered information concerning the practices of cities, and we expect to receive city reports that would be very important developments in understanding how cities all around the world, so not only in Europe where I'm speaking, but from Asia and from other areas, African areas of the world, how cities are actually implementing and participating in these processes. Thank you very much for your attention.
Thank you, Professor Mirko Sosai, for some very important. Yes, please. Thank you, Professor Sosai, for some very important issues you have raised, which arise due to the increasing urbanization across the world. And if any, do I see any questions, or would you like to wait to hear other presentations? Well, in that case, we move on to our next panelist, Professor Alice de Jonge from the Monash Business School, and she will be speaking on governance and international law in Southeast Asia. I think this is a very relevant topic for us, and I give you the floor, Professor.
Thank you so much. It is a great honor and a pleasure to be invited to your honorable conference. I will be giving a few introductory remarks about international law issues within the Southeast Asian region, mostly from a very, very Australian perspective, if you will forgive me. Please interrupt me if you're having trouble hearing with my connection from Australia. From a very Australian perspective, I will begin, as we do in Australia, by acknowledging the traditional custodians of the land on which I now sit, the Wurundjeri people of the Kulin Nation, and traditional custodians of Indigenous lands wherever attendees now sit. From an Australian perspective, from a national perspective, considering the key issue of nationhood being the preservation of independent sovereignty in equal relations with other sovereign states, the Australian perspective goes like this. We sit in a very maritime region in the southern hemisphere. Looking north, looking south, of course, we see the South Pole. That's just a chilly expanse of interest mostly to scientists. Looking north, we see our neighbours in Southeast Asia, Indonesia, the Philippines, Malaysia, Singapore, and going further north, we see China, a large dominant power with which Australia has very strong economic ties and historic ties going way back. I shall not go further back, although there are ties, trading ties further back than colonial settlement of Australia with China and Chinese people. But the Chinese were amongst the first settlers in Australia. So those ties are strong, but China is the largest and most obviously large and powerful sovereign states with which Australia needs to establish equal and respectful mutual relations. And so, given some of China's more pushy activities to Australia's north, we become aware that we need to enter into partnerships with our regional, small, middle-sized and smaller regional neighbours. Our neighbourhood is a maritime region. Our key neighbours, the largest and most important being Indonesia, and other neighbours including Philippines, Malaysia, Singapore, are archipelagic states. Archipelagic states face key challenges in their international relations in that they need, under the UN Convention on the Law of the Sea, to allow transit through their waters, while at the same time preserving sovereignty within their territorial waters and exclusive economic zone, and maintaining control over those areas. That is a key challenge which requires very much a balancing act performed under the auspices of the UN Convention on the Law of the Sea, or UNCLOS. UNCLOS is, of course, one of the major achievements amongst those mentioned in your introduction to this session of international law since the establishment of the United Nations. UNCLOS establishes a framework for international relations within maritime regions, and our region is very much that. And so it is under UNCLOS that those key challenges of allowing strategic passage as required under UNCLOS while maintaining control over sovereign areas need to be balanced. China is a signatory to UNCLOS, unlike, I might add, the United States, which has failed to ratify UNCLOS. It is precisely because China is a signatory to UNCLOS that the Philippines was able to challenge China in an arbitration before the UNCLOS committee, arbitration committee in 2015-16. And the decision was handed down that I'm sure you'll all be familiar with in favour of the Philippines. Tensions, of course, remain in the area of the Spratlys Islands between, particularly around Sabina Shoal, where recent tensions between ships from China and the Philippines have collided. And so how do these states of Southeast Asia maintain their relations with China, a huge economic power with which they need to not antagonize, and their relations with other major powers, the other major power in the world being, of course, America? They need to balance these relations in a way that does not antagonize either side, and hopefully prevents either America or China coming to blows within the Southeast Asian region. Australia has recently signed the AUKUS Treaty with America. Under the AUKUS Treaty, Australia undertakes to purchase several nuclear-powered submarines from America, due for delivery, however, not until the late 1930s, more likely well into the 2040s, 100 years out, that's all, 2040s, can delivery be expected? More importantly, I would argue, the AUKUS Treaty allows for the stationing of US troops in Western Australia and in the Northern Territory at bases, naval bases in both Western Australia and the Northern Territory that allow strike capabilities, mid-range strike capabilities that potentially could be seen as threatening by China. Is that a clever strategy? There are many in the defence community in Australia, and I would tend to agree, that would argue it is neither necessary nor particularly a clever move to take such a stance. More importantly, I would argue, are the kinds of relationships that Australia is entering into with Indonesia. Australia has recently signed a security relationship with Indonesia, where both sides agree to cooperate with the patrolling of maritime transit routes, particularly the Malacca Straits and the Torres Straits and other straits relevant to international shipping. And so under that relationship, it's not a security pact. It allows Indonesia to do something which is very important to Indonesia, to retain its neutrality. It does, however, allow Australia to help Indonesia strengthen its training, education, and technical capabilities to help Indonesia feel more secure about its capacity to maintain its sovereignty in its waters. In other words, to effectively push away or nullify China's ability to project power in any kind of aggressive way. And I would argue that it is those mutually strengthening relationships that are most important for the future of the regions, such as under the relationship that brings together Mexico, Indonesia, Australia, and I forget what the other party is, in a mutually strengthening Korea, South Korea, MIKA. That grouping brings Australia, Indonesia, South Korea, and Mexico together in a cooperation between technical and educational capabilities. So I've probably gone on way too long, but those are a few thoughts about the importance of international law, particularly UNCLOS, in helping maintain a stable region in Southeast Asia. Thank you for listening.
I thank Professor Jonge for her presentation. She has highlighted various issues on the law of the sea, the issue of maritime boundaries, the question of the China-Philippines arbitration award regarding the eligibility of various islands to maritime zones under the UN Convention on the Law of the Sea. She has raised questions regarding maritime security and the passage through international straits, and we thank her for this presentation. And now I see that Professor Pavel Sturma has joined us online from Prague. So I welcome you, Professor Sturma. Well, it's our apologies to you and to also to Professor Sosai for getting you up so early in the morning. We were aware that there's a time difference of 3.5 hours. You are behind us and it's early morning. But what we did not realize that today the daylight saving time ends, and so you are 4.5 hours behind us. So it's very quite early, and we thank you for joining us at this early hour to participate in our conference. So Professor Pavel Sturma is a professor at the University of Prague, and he also holds the distinction of being the president of the Czech Society of International Law. He has also been a member of the International Law Commission and also served as chairman. And further, since we share the last surname in the International Law Commission, we were neighbors sitting together, and I always enjoyed the discussions with him on various issues before the commission. And I thank him for joining us online from Prague. And before his presentation, Professor Sturma has a message for the Indian Society of International Law for this conference. You have the floor, Professor Sturma.
Thank you, Ambassador Singh. Good morning. And first of all, I would like to thank you for your kind invitation to attend your conference. And also my apologies that I was not able to join at the very beginning of this meeting. Anyway, I sent actually a message, my letter by email. So this is just to congratulate to the organizers and to the Indian Society of International Law for this very important conference gathering of many specialists from India and from the world. And of course, on behalf of the Czech Society of International Law, I wish you the full success. And also, I hope that cooperation between our societies will be possible in the future. This time, unfortunately, I was not able to attend in person, but at least I try to attend like that via Zoom. So this is just very briefly the short content of the letter I sent you, Secretary General of the Indian Society of International Law, and then with your permission, I will pass to presentation. Okay, so I will try to share the PowerPoint presentation. If it's possible.
Yes, we are making arrangements to show your presentation.
Okay.
Yeah. I'm told you have to do the screen sharing from your side. If you can share the screen, if you can share your screen with us.
Yes, I tried to do it, but I noticed that the host disabled participants screen sharing. So I'm sorry, I don't know whether I will be able to resolve the technical problem right now.
We are trying to resolve it.
Yeah, and if not, I will speak without it.
Okay, I think you can proceed without the presentation.
Okay, thank you. So, Sorry.
Yeah, please continue.
Yeah. Okay, I will try to continue. Just I see the problem. With my connection. So I would like to actually to address the issue of principle of rule of law in international law. As it is well known, this principle emerged basically in national legal orders as a leading constitutional principle. It's also referred in some jurisdictions in other words like Rechtsstaat or l'état de droit, and it refers to the organization of a state and the submission of all subjects, including state authorities, to law. But what is interesting is that recently the concept of rule of law is also being applied in international law, and this is particularly interesting because the question is whether the meaning of the concept is precisely the same in on national level and on international level. So I would like to speak briefly about the origins of the concept of the rule of law in international law. I will also present briefly some international documents on the rule of law on national and international levels, and also speak about promises and pitfalls of application of the concept in international law. So starting from this first aspect is that the concept of rule of law is not uniformly conceived, and there are different approaches actually to this concept. On a universal level, I mean mostly the United Nations documents, it was not originally present, at least not in the express way. If we look at the preamble and Article 1 of the UN Charter, we can only see some references to justice, respect for obligations, dispute settlement in accordance with international law, and so on. However, a few years later, the Universal Declaration of Human Rights of 1948 includes in preamble also paragraph 3, saying that it is essential if man is not to be compelled to have recourse as a last resort to rebellion against tyranny and oppression, that human rights should be protected by the rule of law. So probably it is one of the first appearance of the concept in important international legal documents. And we can also find the reference in the Declaration of Principles of International Law relating friendly relations and cooperation among states of 1970. If we look at on regional level, in particular in Europe, we can find various places of the reflection of the concept of the rule of law. In particular, the Council of Europe includes this principle in its statute of 1949, and also European Convention on Human Rights of 1950. Here, the rule of law is also referred to in French as la prééminence du droit. By contrast, in some other documents, for example, the OSCE Paris Charter for the New Europe of 1990, we can also find reference to respect for human rights and the rule of law, here in the French version referred to as l'état de droit. So you can see that the use of a term in various languages is not always uniform. Anyway, now I would mention some important documents on the rule of law at national and international levels. And I think that the real mass appearance of the concept and the interest of specialists, practitioners, academics in international law relating to this concept is much more recent, and it started the beginning of this century. In the UN Millennium Declaration of 2000, we can actually find references to rule of law, and I would say that implicitly on two different levels, national and international level. One of the conclusions of the declaration is the commitment to strengthen the respect for the rule of law in international as well as domestic affairs, and in particular to ensure compliance by member states with the decisions of the International Court of Justice. We can see a certain balance of the two meanings of rule of law, domestic affairs and international level, and also the commitment to promote democracy and strengthen the rule of law, as well as respect for all internationally recognized human rights and fundamental freedoms, including the right to development. Another important step is in the outcome document of the World Summit of 2005, where we can find references to good governance and the rule of law at the national and international levels are essential for sustained economic growth, sustainable development, and the eradication of poverty and hunger. So we can see an important link between the principle of the rule of law and the problem of development, sustainable development in the world. Actually, then probably one of the most important and mostly cited documents regarding the rule of law in international law is the Declaration on the Rule of Law at national and international levels of 2012. Here, the merit of the document is that it expressly differentiates between national and international levels, but on balance, it also lacks the precise definition of the rule of law and precise delimitation about question which elements apply at national level and which apply at international level. But there is very important question of the international order based on the rule of law, which clearly refers to the international legal aspect of the rule of law. And at least to quote one important provision from the declaration is that we recognize that the rule of law applies to all states equally and to international organizations, including the United Nations and its principal organs, and that respect for and promotion of the rule of law and justice should guide all of their activities and accord predictability and legitimacy to their action. We also recognize that all persons, institutions, and entities, public and private, including the state itself, are accountable to just, fair, and equitable laws and are entitled without any discrimination to equal protection of the law. So again, we can see various elements of the concept referring to international relations, to not just state but also other actors, including international relations, and some references that are more addressed to states and their subjects at national level. So now maybe it's time to go to some let's say conclusions about it, and I think that we can also speak about the promises, but also pitfalls of application of the concept in international law. The reason is that actually we can see combination of two aspects of the rule of law here, namely rule of law at national level and rule of law at international level. And what is more important, that the concept is not always uniformly conceived and applied. At least it is very important distinction between the formal or a thin concept of rule of law, which doesn't mean more than actually the respect for international obligations arising under international law, and on the other hand, the substantive or broad concept of the rule of law, which goes beyond the just respect for international legal obligations, and includes some elements of the rule of law known already from the application of the concept in democratic states at national level. The formal or elementary meaning of the rule of law in international law is very simple. It means that states respect the international obligations, which is also reflected in the principle pacta sunt servanda. So it is nothing new actually in comparison with the existing state of international law, international relations. But the important question is whether the concept can also include other elements, for example, equality before law, accountability, fairness in application of law, including international law, legal certainty, the exclusion of arbitrariness, etc. I think that it is something which is inherent to the concept of rule of law. The only question is whether all those elements are equally understood by individual states, and whether they can be considered as a part of the principle at the international level now. I think that what is also one of the problems is that we can see a somehow blurred borderline between the two levels, national and international level, when it comes to the application of the concept. And last but not least, I would also point out certain differentiation between general international law and regional subsystems, in particular the EU law, the European Union. Why? Well, because it is very clear difference. For example, if we look at the Treaty on European Union, Article 2, where the rule of law appears as a kind of a constitutional principle. I quote, "The Union is founded on the values for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights, including the rights of persons belonging to minorities." These values are common to the member states in a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men prevail. Okay, so it is quite a strong expression of the principle, and in addition, it is not just a proclamation, but there are also certain powers of the European Union. I mean, Article 7, it is possible to take some measures against a member state that fail to respect these principles, including the rule of law. By contrast, if we look at the situation at general, universal level, for example, in the United Nations Charter, Article 4, Paragraph 1, only says that the membership the organization is open to all other peace-loving states which accept the obligations contained in the present charter, and in the judgment organization are able and willing to carry out these obligations. Okay, so this is basically what I refer to as the basic content of rule of law, meaning respect for obligations arising under international law, but not including additional elements of the concept. So, to sum up, in the EU, we can see the board concept of rule of law expressly included in the treaty, the fundamental legal document of the organization, and even making it one of the conditions of membership. In the United Nations, on a universal level, we can say that the rule of law is present, but more or less implicitly when it comes to the binding treaty instruments. Of course, we have then many recent resolutions of the General Assembly. We can speak about rather basic or thin concept, which mostly means respect for obligations in the Charter. And it also may lead to possible conclusion that in a general international law, rule of law is certainly present, but maybe more as a programmatic principle, something that states try to achieve more than the principle de lege lata, if we take it in the broad meaning, as I already mentioned. Of course, then there are also some other possible problems and pitfalls that may arise from, let's say, not uniform conception and application of the principle in different states, and of course, also certain risk of the misuse of reference to rule of law as a tool for interference into domestic affairs of sovereign state. I think that all very important and progressive concepts like rule of law have certainly very important value, and it is something which reflects the changes, the progressive development of international law today. But at the same time, we should be aware of a risk when, because of the lack of the uniform definition of the concept and uniform application of the concept among states, that it might be also used by, let's say, some powerful states in order to, let's say, exercise pressure against some other states or small countries in the world, and of course the general concepts like rule of law and the failure to comply with some of the elements could be also used as a pretext for some kind of interventions, humanitarian interventions, etc. So I think that this is a possible pitfall of the concept, but in general, I think that it is something which is positive, and it reflects the development of international law in the 21st century. With it, I would like to stop. Thank you for your attention, and of course, I am still here for possible questions and comments. Thank you.
Well, I thank you, Professor Sturma, for your presentation on the rule of law, and I also thank you for your kind message to the Indian Society of International Law on the occasion of this conference, and we thank you for your kind wishes for the success of the conference. And we now have two more presentations which deal with similar topic or different aspects of immunities. Firstly, we have Professor Francesco Rossi of the University of Rome, who will speak on the clash between immunities and access to justice in international jurisprudence. Professor Rossi, you have the floor.
Thank you. Shall I go to the
Yes, you can speak.
Thank you. Thank you, Mr. Ambassador. Can you hear me? Yes. I'm deeply honored to be here. I'm very grateful to my friends of the Indian Society of International Law for their kind invitation and superb hospitality in the beautiful city of Delhi. This invitation gives me the opportunity to share some thoughts on a topic that I've been working on for quite some time, and that is the relation between immunities and access to justice. Now, as we all know, under international law, foreign states, international organizations, and their respective officials are entitled to immunity from national courts. It is in the nature of these immunities to prevent private parties from going to court. That's basically all immunities do. At the same time, however, international law also recognizes individuals a right of access to justice. So you find it enshrined in major human rights instruments, both universal and regional, and it's also considered to be part of customary international law. So we have two rules of international law that are in direct opposition to each other, and of course the problem that arises is how to reconcile them. Now, of course, this is far from a new topic in legal scholarship, and at the most basic level, almost everyone agrees that this conflict should be managed through the principle of systemic integration, which regulates interactions between different areas of public international law. And this principle has gained special prominence within the debates on the so-called fragmentation of international law, a topic that has been very trendy in the last 2 decades of international legal scholarship. Now, the problem with systemic integration, however, is that it doesn't tell us how to solve the conflict. It only says that a judge should take both rules into account when deciding a case, but it doesn't tell us anything about the outcome of this process. It does not establish, in other words, any definite priority between immunity and access to justice. So in principle, both rules might be expected to prevail, to be prioritized, depending on the circumstances of each case. So a generic reference to systemic integration doesn't really solve anything. We have to look at how this plays out in judicial practice, which is precisely what I would like to do in the rest of my presentation. And my specific focus will be on the jurisprudence of the European Court of Human Rights, which is by far the international court that has dealt the most with this subject. The court has developed a really massive jurisprudence on the compatibility of immunities with Article 6 of the European Convention on Human Rights, which contains the right to a fair trial, and access to justice is a part of fair trial. Now, in these cases, the applicants are typically individuals who tried to sue a foreign state or an organization before some national courts, and they failed because of some jurisdictional immunity. And so they go before the European Court of Human Rights, challenging the state that granted immunity and saying that by granting immunity, the state violated Article 6, access to justice. So how has systemic integration worked out in this context? Well, in general, the court has always said that limitations on access to justice can be legitimate, as long as they pursue legitimate aims and they are proportionate to the aims that they pursue. The court has also said that immunities do pursue legitimate aims. The legitimate aim of complying with international law, and in the case of organizations, also the aim of enabling the organization to function. So the legitimacy aspect of the test is not problematic. What really matters is the other prong of the analysis, which is proportionality. And what's interesting is that in this context, the court has developed not one consistent approach, but many approaches. And notably, there are two main fracture lines within the court's jurisprudence. Now, the first fracture, the first split, runs between state immunity and the immunity of international organizations. And these two have been handled by the court in completely different ways. So when it comes to state immunity, the court considers it to be a proportionate limitation on access to justice if the state of the forum, so the state of the court that granted immunity, complied with customary international law. If there was a customary obligation to grant immunity to a foreign state. So in theory here, there is a maximum limit to the immunity that can be granted to a foreign state, but in practice, the limit coincides with the immunity rule itself. So as you see, the court does not really check the human rights compatibility, the human rights legitimacy of state immunity. It merely says that you should grant no more immunity than required by customary international law. So in other words, the approach has been very deferential towards state immunity. And if the applicants remain without any judicial remedies or remedies of any sort, this has no impact on immunity whatsoever. Now, by contrast, the approach to the immunity of international organizations has been strikingly different. Because the court, to the court, whether or not immunity is a proportionate limitation on access to justice depends also on whether the applicants had access to alternative remedies outside of the court that granted immunity in the first place. And this approach was developed in a very famous case, in the 1999 judgment in Wade and Kennedy versus Germany, where the applicants were two employees of the European Space Agency, which is an international organization. They tried to sue the agency before German courts because they had some staff disputes. And they failed. And so they went before the European Court of Human Rights. And in that case, the court found that they had an alternative remedy, because the agency had created an internal board to deal with staff disputes. But the court is clear. If adequate remedies are lacking, then a state which grants immunity to an organization would breach Article 6 of the European Convention, even if immunity is required by a treaty obligation. Which of course you usually find in the constituent treaties of international organizations. This is, as I was saying, the first split in the court's jurisprudence. There's the second one, and this has to do with international organizations. It's internal to international organizations. Notably, the Wade and Kennedy jurisprudence that I just mentioned, the alternative remedies test, as it's usually called in Europe, has been applied only, almost exclusively actually, to the field of staff disputes. Wade and Kennedy was an employment dispute, as I told you. Outside of that field, the court has been much more reluctant. And in particular, it refused to apply the alternative remedies test in another very famous case in 2013, the case of Mothers of Srebrenica, which concerned alleged wrongdoings by UN peacekeepers in the context of the Bosnian genocide. And of course, the powers of the UN Security Council under Chapter 7 of the Charter. So why do you have these splits, right? Now, to be clear, I find that the fact that the court's jurisprudence has no consistency on this matter, this is not outlandish or surprising in itself, because this is in fact typical of systemic integration. As I told you, systemic integration does not create any predetermined normative hierarchy or priority, and thus it leaves a lot of room for judicial creativity. But still, the obvious question is, why do we have these fractures in the court's jurisprudence? Are they justified or not? Well, let me start from the second split. Here I'll be very fast, of course. There would be many things to say, but I'll try to summarize the main points. So the reasoning in Mothers of Srebrenica was criticized heavily for being too short and not particularly compelling. And this is true. Anybody who read the judgment thinks this way. But I think that the underlying rationale of the decision is fact quite clear. The court was concerned of the systemic effects of its decision, particularly of applying the alternative remedies test in a context of mass claims where you may potentially have thousands of claimants. And in this regard, my view is that the rationale of this decision is not too distant from the 2012 judgment of the International Court of Justice in the jurisdictional immunities case, the Germany versus Italy case, where the ICJ said that state immunity applied to reparation claims by victims of Nazi atrocities, even though those people were left without a remedy. Now, essentially, both international courts assume that mass claims arising from wartime events, do not belong in national courts. You may or may not agree with this statement. I believe that there are some valid reasons behind this approach, which I unfortunately do not have time to discuss adequately. But if you don't agree, you are in very good company, because there are national courts in several states, including Italy, Korea, and South Korea, of course, and Brazil, as far as I am aware, that try to challenge this statement and affirm jurisdiction in the context of wartime reparations claims, bypassing state immunity. Now, this trend, however, we must acknowledge that it finds no support in international jurisprudence and is, to say the least, controversial. Now, a few words on the first split that I mentioned within the court's jurisprudence, the one between state immunity and international organizations immunity. Why treat them so differently? Well, here things, I must tell you, get a little weird, because the court has never explained. The two approaches have simply developed in parallel, simply without referencing each other, unaware of each other. But if you read between the lines, you easily realize that probably the key underlying reason is quite trivial. In the case of state immunity, the court believes that there is always an alternative remedy, ipso facto, the courts of the defendant state. So you cannot sue Italy before the courts of India, just sue Italy in Italy. There is a remedy, right? Well, unfortunately, this belief is completely delusional with respect. In certain countries, the government can never be sued, either de jure or de facto. There could be all sorts of jurisdictional limitations. And moreover, the alternative remedies test, as applied in Wade and Kennedy, requires not just the existence of a remedy, but also its effectiveness. So even assuming that the foreign states' courts do have jurisdiction, there is no guarantee that the alternative they provide would meet the basic requirements of a fair trial, even if we keep those requirements quite low. So we have no guarantee that that would be effective. So I move on to my conclusions. First, the treatment of state immunity in clinical isolation from international organizations' immunity in the jurisprudence of the Strasbourg Court, the European Court of Human Rights, simply makes no sense whatsoever. Once you accept that systemic integration between immunity and access to justice can play out through the alternative remedies test when it comes to organizations, then arguably there is no reason in principle not to apply the same test also to the other side of the world of immunities, the side of state immunity. Second point, employment disputes, so disputes brought by employees of states or international organizations, are obviously the main testing ground for this progressive convergence of state immunity and the immunity of international organizations. Because as I said, Wade and Kennedy was developed precisely in the context of an employment dispute. Right now, employees of foreign states can legitimately be left without a remedy, while agents of organizations cannot. Now, you tell me if this makes any sense. And third point, the question is whether this alternative remedies test should always apply. This is also a question that has troubled the court very much, clearly, also in the case of Srebrenica. Now, without going into detail, here the answer is clearly no, or may well be no. In fact, I argue that the subject matter of a claim might legitimately play a role in determining whether or not this test should be applied. And I made the example of wartime reparations claims. But once again, this problem presents itself in essentially the same terms in all areas of immunity. And so it does not depend on who is being sued, states or international organizations. Thank you very much for your attention.
I thank Professor Rossi for his illuminating presentation on the practice of domestic courts in relation to immunities. He has spoken about immunities of states and immunities of international organizations, and also where there were questions arose between states, including matters which went up to the International Court of Justice. But now we have our next panelist, Mr. Jamshed Ahmed Siddiqui. He is from the Center for Trade and International Law, and he will speak on the immunity of state officials, a challenge to progressive development of international law.
Thank you, Chairperson, and thank you, ISIL, for giving me an excellent opportunity so that I can present my thoughts on what is going on. As Professor Rossi has already covered the immunity to state immunity and immunity of international organization, I would like to put some shade on the immunity to state official and covering all the aspects related to immunity. If somebody can help, that presentation will be there. Yeah, thank you so much. Yes. So this paper is dealing with the immunity to the state officials available to the state official, particularly dealing with the foreign criminal jurisdiction. And we can find that on the conceptual understanding of the immunity, yes, thank you. Yeah, so here we are dealing with the first understanding, the conceptual understanding of the immunity. You will find there is no multilateral treaty which define immunity as such, and it's commonly perceived as a claim to be free from the constructive order adopted by a foreign state. And there are several rationale given behind the granting immunity, and that rationale imbibing the idea of equality, dignity, and sovereignty of a state, practical courtesy, comity, and reciprocity, and the functional necessity that it is necessary to grant immunity to each other officials to effectively perform their functions. So when we are dealing with the types of immunity available to state official, it is divided into two. It's related to personal immunity, what we call immunity ratione persona, and it's cover all sort of act performance to a state official, whether in a private or official capacity. But this immunity is available to high-ranking state official, for example, head of state of the government, or for after the arrest warrant judgment, we can assume that the foreign minister of a state. and on the other hand, immunity rational materia, which is available to the function to the state official for the function they have performed on behalf of the state or the function that attributed to the state. So what we are doing in this paper is basically the notional understanding of immunity under customary international law, the recent development that fights against impunity, particularly the exception of these functional immunity that's going on under the work program of the International Law Commission, and a possible way forward that how the International Law Commission may proceed giving these multipolar or rising multipolar world. So if we talk about the functional immunity scope and exception, as I've told, that functional immunity that available to all state official for its official act, but the official act itself becoming a matter which defined differently by the different domestic courts. So if we see the International Law Commission view on the official act, that it has to be based on immutability. If the question is imputable or attributable to the sending state, even after it did not expressly order or sanction, that act has to be attributed to the as an official act. On the other hand, if we take the view of the domestic courts, you will find that there are the instances where the court says that if an act is pursuant to crime pursuant to international law, then act itself cannot be called as an official act. This reasoning is quite a problematic in terms that you are denying the act itself as a official act. For example, if you say the ex parte Pinochet, Attorney General of Israel versus Adolf Eichmann, there is a reasoning that committing certain crime pursuant to international law, for example, torture, war crime, that act cannot be attributed to the act of the state, and functional immunity cannot be argued. My understanding says this reasoning is a problematic. Tomorrow you will come and say that your act is a forced labor act, which is our domestic law provides some reasoning, and that cannot be attributed to the function of the state, because these reasoning negate the very idea of the immunity itself, because it says the question of exception does not arise, because you cannot even claim this is not a function of the state to commit war or commit torture, while we know in very practical parlance that war crime or this sort of crimes, the state involvement is almost visible. But in recent the jurisprudence of these the traditional approach of granting the immunity to state official is now diluting, in terms that the jurisprudence, the legal jurisprudence suggests that last couple of decades there has been a trend where the functional immunity granted to state official is declined. The court has declined the immunity in several cases, particularly for the alleged crime pursuant to international law. Now ILC, if we deal with the work program of ILC, so ILC has started its work from and included a chapter of the immunity to state official from foreign criminal jurisdiction in 2007. Now ILC is working on this Article 7, which is talking about the exception to the immunity res materia, what we call the functional immunity. And ILC included that the functional immunity functional immunity did not apply to the crime of genocide, crimes against humanity, war crime, and crime of apartheid and forced disappearance. But there has a challenges that ILC is facing for last couple of years in battling and negotiating this Article 7. Is one of the prominent article in this in ILC's draft articles on state official immunity to state official from foreign criminal jurisdiction, and there are many challenges that ILC is facing. First and foremost is that there is no consensus among the state. So state has represented a very mixed approach while making their submission before the ILC. There are some states like Australia, Switzerland, Poland, etc. are supportive, while some states like UK, Israel, Russia, Japan, and Saudi Arabia are really critical, while other like Germany, Malaysia, and Republic of Korea held a very neutral or sort of ambiguous view regarding this position. There is also unclear position of ILC, how ILC is proceeding with this whole article, whether the ILC is looking or codifying certain or existing customary international law as a lex letter, or is a desirable direction for the progressive development of international law, what we'll call as lex ferenda. So ILC itself is not clear in that fashion. So that clarification is become very important in terms of those states who consider these listed alleged crime which granted which will be not available for the functional immunity is not a customary international law rule. So how the way forward ILC can proceed is that, as I have already told, there has been a jurisprudence where the state officials, functional immunity of the state official has been denied for the alleged crime pursuant to international law, for example, genocide, war crime, and the ILC has to have the strength, may focus on strengthening the normative basis of the draft article as suggested by Chona Andro Pacquiao in her article. So the thing is that the ILC has to put more weight to concretize the normative basis of the each and every crime, because the allegation that the state are making, or the suspicion the state are making, that all alleged crime does not reflect the customary international law. But ILC may took certain crime to concretize normative basis of certain crime pursuant to international law, for which the jurisprudence is clearly available, for example, the war crime and genocide and crime of torture. With this notion, I would like to stop here. Thank you so much.
Well, I thank Mr. Siddiqui for his presentation. He has focused on the work of the International Law Commission dealing with the immunity of state officials from foreign criminal jurisdiction. And he has highlighted the differences within the Commission on the question of exemptions from immunity. Now, in the Commission, there is no difference as regards the liability to face trial for criminal acts before an international court or tribunal. The distinction here is that these draft articles deal with the jurisdiction of another state, an individual state. In this case, states are not willing to accept the same obligation to submit their state officials for trial before a foreign state. And this is where the debate is. The demand for doing away with the exception of immunity or not recognizing immunity was raised by some members of the Commission based on the separate opinion given by 3 judges in the well-known immunities case. And based on that, they want to raise the issue of certain acts for which state officials will not enjoy immunity. Now, this is not accepted by many other members, and including states in the 6th committee. And this debate has been on for several years now, and I don't see any easy solution to this issue. Now we are very close to the end of our time, so if there are any questions, anyone would like to ask a question? Yes, please.
Am I audible?
Yes.
My question was for 2 professors in particular.
Is your mic on?
Oh, it's on.
Yeah.
So one was for Professor De Jong. Is she with us?
Can we check if the online participants?
All right. So the question was that we talked about the on the effect of UNCLOS on the Southeast Asian region, and in particular the case between Philippines and South China on the South China Sea as well. So one of the particulars of that very case was that China had decided not to participate in the proceedings and had sent a note verbal on the same to the PCA. So do we see that even keeping the binding or non-binding effects aside, and a need for a reform in the settlement of disputes regime that the UNCLOS currently follows under both Annexes 6 and 7? And if yes, how would it benefit the Southeast Asian regime, which is in dire need of a comprehensive settlement of dispute regime because of the lack of agreements between states in these regards? Should I say the second question or should I wait for?
Is it on the same? Yeah.
I understand the questioner is addressing China's non-presence before the Arbitration Commission, and I didn't quite catch the details of the question about UNCLOS. Its benefits for the region. Is that the question?
The question was, does the UNCLOS need a reform in its settlement of disputes regime? And if yes, then how would that benefit the Southeast Asian region in particular?
The supplementary disputes settlement regime. The UNCLOS regime, including all aspects of its dispute settlement regime, establishes the key principles of international law. Now, as we know, one of the wonderful things about the key principles of international law is that they are ideals. And as with individual people aiming to fulfill all of their ideals, ideals are more often honoured in the failure and the breach than they are in the honouring. And we have seen again and again through the history of international law, states either refusing to appear or simply ignoring the decisions of eminent international forums, including the ICJ, which was somewhat ignored by America in the Nicaragua case. And so these are the what are often alleged to be the failures of international law. But like the rules of any game, if you like, the rules are important. They are important for sending messages about what should be. And those messages are recognized, if not always respected, by the international community. In fact, those rules are what create the sense of an international community. And so the world is aware of China's failure to respect the rule of law in this regard. China is aware of that awareness and is itself aware of the way in which it is perceived. And so just like the observer or the umpire at a game or a match, that awareness does never prevent breaches and lack of respect for the rules, but it creates the community of the rules. And so that community of rule of law is the key benefit for smaller Southeast and Middle power nation states, including throughout the region.
Thank you, Professor. I would just like to add to that. While the US disregarded the ICJ's decision in the Nicaragua case, the US itself felt the need to approach the ICJ when it came to the question of the American hostages in Tehran. And even Iran.
China has approached world tribunals as well, yes.
And even Iran, while ignoring the ICJ decision in the hostages case, has recently approached the ICJ claiming certain violations of some peace and friendship treaty by the USA. So when states see it in their benefit, they approach international courts. And in general, the decisions of the ICJ have been implemented by states, although there are a few exceptions. Thank you.
And of course, thank you very much for that very relevant.
Any further questions?
Point.
Yes, you had another question.
So my second question is to Professor Rossi, which is, we've seen over the years the concept of immunity has completely been out of international criminal law per se. We've seen the ICC deny it in the Omar al-Bashir case. We've seen it being denied in human rights cases. So my question is this an opinio juris still relevant to international humanitarian law only because of the decision of the arrest warrants case? Or do we see it dwindling there also because the Belgian warrant was actually for war crimes against Hissan Habre, if I'm not wrong? So it's still a part of international criminal law, but because the ICJ follows customary international law of the international humanitarian principle as was followed back then, I think it was renounced.
Thank you very much for your question. I think perhaps my colleague to the left is more qualified than me to answer that because it actually sounds closer to the topic of his presentation.
Yes. Thank you so much for the question. So the question is that the warrant issued by the ICC, you need to understand the two aspects that the immunity available in the customary international law and ICC is a treaty obligation. The Article 26, if I am not wrong, it says that immunity is not available crime mentioned under the Rome Statute. So on that percent, ICC gets legal right to issue arrest warrant, and all member state of Rome Statute is legally obliged to arrest and prosecute the person against whom the arrest warrant has been issued. Now the question arises, what about those who are not the member of ICC? And you are exercising the jurisdiction, criminal jurisdiction to that state officials. Now here the idea come of universal jurisdiction, and the problem come when we are dealing with this immunity aspect, which is coming from customary international law. For example, India is not part of Rome Statute. So the immunity under customary international law is still very well relevant. And where the ICC is that is a separate treaty binding on the member state, and ICC has legal right to issue arrest warrant and member has to comply with. Thank you so much. Yeah.
Russia is going back from its commitment.
Russia is going back from. I think Russia is not part of ICC. No? I don't think so. Russia is a member state of ICC. Yeah. International Criminal Court. No. ICC exercise jurisdiction because Ukraine is a member of ICC. So crime committed by the member state or within the territory of the member state, then ICC can exercise jurisdiction. It does not matter that the perpetrator is the member of the Rome Statute or not. Even if the victim is a member of the Rome Statute, that ICC get legal jurisdiction to issue arrest warrant and investigate.
Well, even in the case of the ICC, they have been facing this issue of their warrants not having the desired effect. President Bashir of Sudan, despite the warrants against him, was able to travel freely to various countries, and the ICC chamber even issued a decision saying that Jordan was, by not arresting him, was in violation of its obligations under the ICC statute. So these are difficulties which the ICC is facing, and in particular, the ICC has found is we find that states are more willing to cooperate with the ICC in investigation and prosecution when they see that it is convenient to have a particular person removed from the scene. So if you have an opponent whom the existing regime sees as a future threat, and if he is wanted by the ICC, I think they are all ready to cooperate. But when it is a person in power or close to those who are in power, that cooperation is not forthcoming. Now, yes, Professor Sturma, you wanted to say something on that.
Yes. Thank you very much, Mr. Singh. It is an extremely interesting discussion, and it recalls me very much the difficult debates we had within the International Law Commission regarding the topic of immunities of state officials from foreign criminal jurisdiction. And I would like to mention that actually next year the Commission should complete a priori the second final reading of draft articles on immunity of state officials. Second reading started this year, but only one part of draft articles was discussed, so it should be finalized next year. Maybe, I don't know, maybe it may take longer than 1 more year, but it is close to the end. But it's also fair to admit that the most difficult issues, including exceptions to immunity ratione materiae, Article 7, will only come next year. However, I think that there are two very important aspects. That one is the immunity of the officials regarding national courts of other states, and this is for the topic of the Commission. And mostly governed by customary international law, or at least the emerging practice, because it is clear that several states have different views on the exceptions, and also not only views expressed in this committee otherwise, but also the practice of national courts is not the same. But at least in some states there is really emerging practice concerning prosecution of crimes under international law, even if committed by foreign officials. However, I think that it is not so problematic when it comes to ordinary officials or soldiers. The problem, I think that this is maybe what complicates the debate. The problem is when there is an attempt to prosecute, to try high-level state officials of another state, because then, of course, it attracts very much the attention of everyone. The problem of the ICC, well, it is something that the Commission carefully tried to exclude from the scope of draft articles on immunity of the officials, because it is governed by special treaties, conventions like the Rome Statute. So the Commission made it very clear that draft articles should not address the immunities or the exceptions to immunities before the International Criminal Court or other international tribunals. Of course, it is also somehow in the shadow of the discussion of the decision of the ICC in al-Bashir Jordan case. And it also created very heated debate within the Commission. But I think that the very important aspect is, and this is about the cooperation or non-cooperation regarding arrest warrants issued by the ICC, is that the clear exception or to immunity of state officials, including the high-level state officials that may join immunity ratione personae. This is the rule which is certainly clear and binding on all member states or parties to the Rome Statute. The real problem, and it is in al-Bashir, but also in some other cases, including the recent arrest warrants concerning President Vladimir Putin, is when the state officials of states non-parties to the Rome Statute are implicated. And then it creates a really very complex situation of the conflicting obligations for states, parties to Rome Statute, that should cooperate with the ICC, of course, but they should also act not in violation of other rules of international law, as an international law concerning immunity of state officials of states that did not exclude, did not waive the immunity of state officials because they did not sign and ratify the Rome Statute. So here again, I think it is the interesting question of possible conflicts of north in international law, and again the problem of systemic integration of international law should come into picture. But I think that we are not very close to the real systemic integration here, because as I know, many states, and also important part of doctrine of international law, maintain that the exclusion of immunity, Article 20 of the statute, is a treaty-based provision and not customary international law. But the ICC in al-Bashir, Jordan, said that this is a customary rule of international law, and hence we have a certain dispute between, let's say, the state practice and views of important part of doctrine and the views of the other part of doctrine and this particular decision of the ICC. And I think the situation is in an impasse now, and I think that it will be for the future practice to resolve the problem. But I think that this particular problem of immunity before the ICC is different from the problem of the articles on immunity of state officials, because this is the problem of immunity in the horizontal state-to-state relations only. And here I think that the Commission at least very clearly confirmed that there are no exceptions to the immunity ratione personae, the immunity of the highest state officials as far as they are in the office. But I think that the step to limitation of immunity in draft Article 7 is at least a very important step in the progressive development of the international law. But let's see the end of the discussion possibly next year. Thank you.
Well, thank you, Professor Sturma. I see no more requests. You want to? No. Well, we have overshot our time, and so I will give now the floor to our panelists if for any final comments which they would wish to make, any observations. Professor Sosai, if you would like to say something.
No, I would like just to thank for the excellent chance to listen to the other contributions to this discussion. I enjoyed very much this important conference, and I send my greetings from Rome to all you all. Thank you very much.
Thank you very much, Professor Rossi.
Likewise, just a greeting to my colleagues, those that are here in the room and those online, and thank you all for this great opportunity to be here at the conference. Thank you.
Well, with that, I thank all our panelists for the wonderful presentations they have given, the supplementaries which they have addressed, and with that, I close the session and once again wish you, for those who are here present from abroad, I wish you a safe journey home and we thank you. And I hope that in future conferences, we would have the pleasure of seeing you here in person. Thank you.
With that, we come to the end of the second session at Maple Hall on International Law. I thank all the panelists for sharing their insightful thoughts on several intriguing aspects of international law. I also thank our chair, Ambassador Narendra Singh, for chairing this session. Now I would like to request Professor G.G. Hegde, EC member, Indian Society of International Law, and Associate Professor, NLS Bangalore, to felicitate him.
You should felicitate our panelist. Okay.
The chairperson, of course.
Do you have one for him? So thank you very much.
Thank you, sir. Thank you, sir.
Thank you.
Thank you very much, my friend. Thank you. It's been a pleasure.
I know the immunity is such a wide topic.
Lunch is arranged in the hall itself. Enjoy your lunch and please be back here at 2 p.m. for the next session. Thank you.
I've got to see you. No, my name. Okay. So that is 375. Number.
Good afternoon and welcome everyone to the day 3 of 10th International Conference on International Law, Issues and Challenges organized by the Indian Society of International Law. This session is on investment law in global economy, international law as a guiding force. Our chairperson for this session is Professor Prabhas Ranjan. He is a professor at Jindal Global Law School. He holds a PhD in law from King's College London. He is also a visiting professor at National University of Juridical Sciences, Kolkata, and an international fellow at the National Institute of Military Justice, Washington, D.C. Previously, Dr. Prabhas has taught at South Asian University. He sits on the editorial boards of various international journals, such as Journal of World Investment and Trade, BRIL, Asian Journal of International Law, and various other prestigious journals. Dr. Prabhas was a member of the team that drafted the 268th report of the Law Commission of India on 2015 Draft Model India Bilateral Investment Treaty. He regularly contributes to various opinion editorials in India's leading national newspapers like Hindustan Times, The Hindu, The Indian Express, and has already published nearly 200 opinion editorials. Now I would request Dr. Prabhas Ranjan to make the opening remarks and also deliver the keynote address.
Thank you very much for that generous introduction. I'm extremely grateful to the Indian Society of International Law for giving me this opportunity. The task that I have at hand is to chair this session and also offer some remarks or comments on international investment law. Now, before I turn to our esteemed speakers one by one, I don't want to make a very long remark, but just to sort of set the ball rolling, I want to contextualize this discussion that where are we when it comes to international investment law? It's cliched to say that international investment law is at crossroads or is facing what many scholars call as a legitimacy crisis. Now, this legitimacy crisis has erupted because of the large number of claims that several countries, developing countries and developed countries, have been facing. If I give you the statistic according to UNCTAD, the first BIT claim, or the ISDS claim, as we all know, was brought in 1987. And in the last 30 plus years, we have more than 1,200 ISDS claims that have been brought against countries. This includes largely developing countries, but also developed countries like Canada, Spain, the US, etc. Now, the explosion in the number of claims has triggered this debate on whether international investment law unduly curbs the regulatory discretion or the right to regulate of sovereign countries. This concern has become even more profound because we find several instances where foreign investors have brought challenges against state for the actions pertaining to public health, for actions pertaining to environmental measures, climate change, etc. India too has had its fair share of claims being brought. According to the UNCTAD database, there are more than close to 25 claims that have been brought against India. But informally, I hear that the number of claims can be much more. And this brings me to another very intriguing aspect of international investment law, which is the lack of transparency. Many a times you will find that arbitration tribunals give their decisions, or what are known as awards, and these awards are not publicly available. Now compare this with any other international law system. Can you imagine the ICJ giving a decision and that decision not being publicly available? Or can you imagine the WTO panel giving a decision and the decision not being publicly available? But in investment law, this is a major problem, that many of these awards are not publicly available. Just to give you one example, the Vodafone award against India, which was issued in 2020, is still not publicly available. And that is because it's arbitration and is bound by confidentiality and stuff like that. But it makes things very difficult for researchers, for students, for larger international law community who want to read these awards, analyze the reasoning of the tribunal, and see or sort of make policy recommendations or legal changes. And this is something which, as a student of international investment law, I have been grappling for last 15, 17 years. The other important issue, before I turn to the speakers I want to highlight, is something which I have discussed in my recent book on India and ISDS, is that I present international investment law as a story of two competing narratives. There can be several narratives, but I have picked up on two competing narratives. One narrative, which is the dominant narrative, which has several supporters in developing countries, including India, is what I call as the Philip Morris narrative. Now, what is this Philip Morris narrative? This narrative principally is that whenever a developing country or a developed country adopts a regulatory measure for protection of public health, or for environment, or for any other sovereign measure such as taxation, you have the foreign investor knocking at your doors with the bilateral investment treaty saying that you have violated the expropriation provision or the fair and equitable treatment provision, so on and so forth. And then you have to fight this expensive arbitration before these international arbitration tribunals. It may often happen that the arbitration tribunal at the end of the day will rule in favor of the state and not in favor of the investor, but that would take about 5 to 6 years, and you have spent a lot of money contesting and fighting this claim. So the Philip Morris narrative basically is that international investment law unduly intrudes into the sovereign regulatory space of countries, where states are deterred or forbidden from taking regulatory measures in public interest. And this is a narrative which, for example, would resonate in India and in many other developing countries. While I completely accept and I completely respect this narrative, but there is a competing narrative to this as well. And what is the competing narrative? I call this as the UCOS narrative, based on a case that was brought by a foreign investor by the name of UCOS against Russia. And what was this case about? This case was about a textbook example of a state going after a company and targeting that company for a host of reasons, political, etc., etc., and because of which the company basically became bankrupt, and then brought a BIT claim against Russia, and the tribunal awarded a huge claim in favor of the foreign investor. Now, this narrative, in a way, is a counter to the Philip Morris narrative. Why? Because this narrative basically tells us that while you have instances of foreign investors bringing claims against genuine regulatory measures of the state, you also have instances where states might abuse their public power, because of which the foreign investor has no other option but to bring the investment treaty claim against the state. So, in my opinion, the reality is never in black and white. The reality is always gray, it's always nuanced. And I think the reality of international investment law, or the story of international investment law, falls somewhere in between these two competing narratives. In my book, I have analyzed all the high profile cases that were brought against India, and I have taken a call whether they are closer to the Philip Morris narrative or the UCOS narrative. I'll not tell you the final conclusion, in the hope that you will buy the book and read it. But these are the two competing narratives which I want to present before you. International investment law is indeed replete with several problems. There are several reform proposals which have been made, including a proposal or discussions happening at the UNCITRAL Working Group 3 on creating an investment court with an appellate mechanism. So with these words, I mean, these are just sort of very introductory remarks which I thought I'll make just to contextualize the discussion. And this hopefully will make our speakers present their views on this very interesting topic. So without any further ado or wastage of time, I'll turn to our first panelist, Ambassador Rohan Pereira, a former member of the ILC. I think he's joining us online, and he's going to speak on a very interesting issue in international investment law, that is the most favored nation clause. For those who know the White Industries case, they would know that India lost the case because of the interpretation of the most favored nation clause. And he's going to talk about the MFN clause and the International Law Commission's work on the MFN clause. Ambassador Pereira, over to you. And I'll request all the panelists to please restrict their views to about 12 minutes or so that we can have some questions towards the end. Thank you. Do we have Ambassador Pereira online? Maybe if not, then we can come back to Ambassador Pereira a little later when he's there. Maybe I can turn to the next panelist. Is Jyoti Singh here? Okay. We then turn to the next panelist. That's Miss Karishma Ramachari from South Asian University. She's going to speak on environmental regulations in international investment agreements. Karishma, about 12 minutes. Yeah. Thank you.
How do I okay. Respected chairpersons, Pravas Ranjan, dear fellow speakers, delegates present in this Mapple Hall, ladies and gentlemen, a warm good afternoon to all of you. Today, I shall present before you on the topic environmental regulations in international investment agreements. So, in an overall overview, I shall go into the aspects of why there is a need for environmental regulations, particularly in international investment agreements, and how states are accommodating these environmental provisions in their agreements. Let's dive into the presentation. Okay. So as Sir has also talked about in his keywords about the history of bilateral investment treaties and how it has come into being, we also should look back on how the history of bilateral investment treaties came into being. So, in an all, bilateral investment treaties was brought into force because for the standard protection of foreign investors and their investments in the host state. So bilateral investment treaties consist of substantive standard of protection treatment as well as access to arbitration for foreign investors. This and ultimately resulted in a loss of regulatory process of the host state, more specifically in sectors such as environment, social, cultural, and other political interests. Now, as we know, climate change is one of the major and challenges of humanity today. States are trying or states are initiating its objectives and its compliance towards environmental regulations. So as they are taking steps to comply with international environmental obligations, such as present in Paris Agreement or UNFCCC, so there has been a rising amount of investor-state dispute settlements, particularly in environmental regulation, as per statistics, 175 cases that has been risen in environmental regulations. So to understand these tensions between investment protection obligations and climate obligations, let's take this case in hand. So this is an Eco-Oro versus Colombia 2021 case. It was brought forward in ICSID. So the Colombian government banned mining in the Paramo ecosystem, wherein the Canadian company Eco-Oro partly did its mining operations. Herein, the majority found a breach of legitimate expectations as well as minimum standard treatment. However, I would like to highlight on the dissenting opinion that Philip Sanders gave, where he mentioned specifically that the majority failed to consider the environmental need or the change in environment, the need for change in environmental sector, and the need to bring regulations specifically in relation to climate change. He also pointed out another point that he pointed out was the tribunal's interpretation of minimum standard treatment as insufficient in this case, although this would be another debate. Herein, I would like to highlight that there is a conflict wherein states try to bring regulations for environment. However, this regulation as such is conflicting with the investment obligation or the standard of treatment that they give to investors. So as investors bring forward the claims to the various tribunals, states vehemently has to suffer the expensive cost, as also pointed out by sir. So let me dive into another case to highlight this point. So this is a recent case, RWE versus Netherlands. So although this case was brought against the legislation, Netherlands legislation of national coal ban for their objective to end fossil fuels by 2030, which is a climate objective. So RWE brought claims against this legislation. Although this case was discontinued later, however, I would like to focus on the cost incurred by the Dutch state, which was estimated over 3.6 million euros. This became a contested point of criticism in this case. I would also like to highlight another case in this aspect. Let me move into this case. So this is an Infra Capital versus Spain 2021, wherein infra-capital brought claims against Spain for their investments on photovoltaic plants. So herein, Spain brought regulatory measures with an intention to address the unsustainable cost of its renewable energy and to eliminate structural deficit of the system and mitigate them. However, the tribunal found that the retroactive use of this regulatory measure and it awarded 24.9 million euros. So this specifically highlights the cost incurred by the states. So as such, how are states trying to adapt into these challenges? So as we know, states are mainly using three points that I would like to highlight that states are using to rectify this issue. Is first specifically the termination of BITs. So several developing countries, such as including Ecuador, Bolivia, South Africa, Indonesia, and also India, has terminated their old bilateral investment treaties in order to change with the changing circumstances. Also, in a recent event, I would like to highlight the European Council approved the withdrawal of Energy Charter Treaty on May 30, 2024. So this is one step that states are taking and are trying to renegotiate bilateral investment treaties. Another important point is several states such as Brazil has not adopted the method of termination as a whole, but modification of the bilateral investment treaties. To point out how states are accommodating environmental provisions in the BITs, let's take a note of this slide. So here, environmental provisions are being added as a preamble clause to protect the environment, or even as a substantive provisions directly focused with environmental protection. So herein, what states are doing is they are trying to accommodate the state's right to regulate, the element of state's right to regulate in a larger scenario. And therefore, they are also creating environmental protection as a carve-out for standards of treatment. Also, in another United States, Mexico and Canada agreement, so they have added environmental protection as a general exception. So all these factors or all these steps are being taken to address the issue of climate regulations in investment agreements. So let's also move forward to address how these three cases that I have discussed with you and how environmental regulations are being brought forward into international investment claims, ISDS.
Karishma, you have 2 more minutes, please. Thank
Yes, sir. So, as such, I would like to highlight on 3 main pointers. There is so the Unicentral Working Group, which has started to work on the reformation of ISDS. So it started working in from 2017, and I think so. They have one more final working group coming in next year, I think so. So they have suggested for a development of standing multilateral investment code to replace the current ad hoc system of arbitration and an opt-in treaty to apply for reforms to existing investment treaties. In an overall, I would like to point out that it is important that states look into the balancing method of how environmental obligations as well as protection of investment and the protection of investors and the investment is balanced, and how states could encourage foreign investors to achieve climate obligations as such in a larger scenario? Thank you.
Thank you so much, Karishma. I think the cases that you have highlighted would fall closer to the Philip Morris narrative, which I mentioned initially. You can have a seat and we can have questions once we have heard all the presenters. And in fact, these cases which Karishma has mentioned in a way go to the heart of the issue. That is, if countries adopt measures to protect the environment, you have the foreign investor knocking at your door with an investment treaty claim. This has started to affect European countries in a big way, as she pointed out, and therefore you would see a large number of European countries walking out or exiting from the Energy Charter Treaty, which the fossil fuel companies have been using to bring ISDS claims against many European countries. Okay, now let me, so thank you very much for those insightful comments. Let me now turn again to Ambassador Pereira. Is he available online? Ambassador Pereira, are you there?
Yeah, he's available.
Yeah, okay. Ambassador?
I'm here online.
Okay, right. Thank you very much. So the floor is yours. You're about 12 to 13 minutes. Thank you.
Thank you very much, Mr. Chair. It's a great pleasure for me to participate even virtually from Sri Lanka. It's very interesting discussion. Now, Sri Lanka has a special interest in investment protection treaties because Sri Lanka's dispute with a company named AAPL, Asian Agricultural Products Limited, for the first bilateral investment disputes go before the ICSID, or the International Center for Settlement of Investment Disputes. So, with that background, that I thought I should join this discussion. And thank you very much for providing for my online participation. Today, the scope of my presentation, in fact, I sent a brief paper on the outline, is the ILC, the International Law Commission treatment of on the scope of application of the MFA clause. When the International Law Commission, way back in the late 90s, decided to include this item on the work program of the International Law Commission. Because it's not an easy task. There was a prolonged debate as to whether this is a subject, the MFN clause, subject fit for discussion by the Law Commission. The popular notion was that the International Law Commission is concerned with matters of public international law, and MFN properly belonged to the field of trade law. And that had done amount of work. So that was a long discussion we had, whether it should be included in the work program of the ILC. But finally, they agreed to have not a formal working group, but what is called a study group, without special rapporteurs, but with two co-facilitators. Donald McRae of Canada, a well-known international trade lawyer, and myself, Sri Lanka. We examined essentially the case law that had been before the international arbitral tribunals, and then we have dealt with what is called the Maffesini problem, well-known case of Maffesini versus the Kingdom of Spain. Now, what came through the reading of these awards was that
the language that you use in incorporating MFN clause is crucial to frame it very broadly, to make quite unintentionally draw provisions from other treaties. So it's a comparative exercise, and therefore go well beyond the intention of the parties to the treaty. So that was the problem that we had to deal with. And the way we set about it was to examine these clauses and recommend that MFN clause must be drawn up in very precise terms. For example, in the Mafazeni case, that use the words on any quote on any matter unquote. Now, when you use a phrase like that, on any matter, then it's you open it up to all sorts of interpretation. Now, then the question arose: can you make use of the MFN clause to attract more favorable dispute settlement provisions? For example, in a third party's treaty, we may have a ESM provision providing for non-exhaustion of local remedies. In other words, enabling the parties to go direct to international arbitration rather than exhausting domestic remedy. So that is the type of problem that we had to contend with. And then what we recommended was that, and also states had by now begun to, in their own interest, to formulate provisions, bilateral treaties, to say these clauses will not attract MFN treatment. In other words, dispute settlement provision will not attract MFN treatment. That is, say, MFN treatment will be limited to the grant of substantive treatment, not to dispute settlement. While others felt out and said ESM provisions will apply to articles X, Y, and Z. These were different devices that member states resorted to for greater certainty in international arbitration. Now, the study group, we thought it would be most useful for participants. We could give them a set of model MFN provisions. And to our report, we appended a set of model, which may be of practical use. Arbitrators, parties, investors. So that is the way that we pointed for greater certainty in international arbitration. So I think I will stop there, Mr. Chairman, and I'll answer the questions if there are any. Thank you very much.
Yeah, thank you very much, Dr. Pereira. That's very, very useful. We'll come back to you once we have heard from all the presenters. But very quickly, some sort of preliminary comments. The ILC's work on MFN is undoubtedly very, very significant. And whenever I teach MFN to my students, I always refer to the ILC's work. And you have very, very, very correctly pointed out that there are different ways in which the scope of the MFN provision can be narrowed. And countries have started doing this in their investment treaties, which is to exclude specifically application of it to dispute settlement, etc. There's another model that some countries like India have followed, which is to altogether eliminate the MFN provision from its investment treaties. Now, whether that is a good or a bad option, the jury is still out on it, but that's another option that countries like India are exercising. Okay, now I turn. So thank you very much for those comments. Yeah. Now I turn to our next panelist, Ms. Jyoti Singh. She's also joining us online. Jyoti, are you there?
Yeah, thank you so much, Prabhas.
Yeah, you have
You all
about 12 minutes.
hear me?
Thank you.
Yeah. So I have already listened to few speakers, and I have also heard Professor Prabhas Ranjan speaking about the introductory remarks he has given about the investment law and the India's encounter with various cases. So I'll just take that a little bit forward, and I will be focusing my 5 to 7 minutes lecture on the recently signed India UAE bilateral investment treaty, which has just been enforced by the government of India and the government of United Arab Emirates, and it was enforced on August 31st, and it was signed during, I think it was signed on 13th February 2024. So this is a very, if I can add, it's a very big achievement for both the countries, because after the model BIT was introduced in 2016, it came into public domain. After that, we can tell that this is the first proper bilateral investment treaty signed by Government of India, because the 4 treaties signed before this were actually not, the investment is not very much on a very larger scale between the two countries, whether it's Kyrgyzstan or Belarus, Taiwan, and Brazil. Of course, is not a BIT. It's just it's just an investment facilitation treaty. So many people have this thing in their mind also, that that's also a BIT, but actually that's not a BIT. And this marks a very watershed kind of movement for Government of India, because this treaty was being negotiated for a very long period. Means the last one was signed in 2013, and the date of termination was in I think, if I can recollect it rightly, it was in September 2024. So before the end of the treaty, the new treaty has come into picture. So of course it's a very good thing for both the countries. Investors of both the countries are getting benefits, of course. But coming to the core points, the things which have been compromised, the articles which have been compromised, if I may say so, between both the countries, is that India has shown a flexibility, and it has accepted the definition of investment in a very different kind of way, because it's not a enterprise based definition, and it's not neither an asset based definition. So the term is being mentioned is just investment, which is a very unique kind of definition, because either India in model BIT has included enterprise based definition, and before model BIT it was asset based definition. So what is now there in the definition of investment is a very different kind of article which has been included. And of course now portfolio investment also has been included. Model BIT says that foreign portfolio investment is excluded from the definition of investment, but in the present BIT, the model BIT in the present BIT, the India UAE BIT has included portfolio, which I will say is a big flexibility shown by the Republic of India to the UAE investors. Secondly, which is a very landmark flexibility which has been shown by the Republic of India, is the duration of exhaustion of local remedy, which has been lessened to 3 years. In model BIT it was 5 years, which has been lessened to 3 years, which is of course a big compromise from the part of the Department of Economic Affairs, or the authorities who are sitting in the negotiating table. So it is of course a very big thing. But if we say that the UAE side were not at all ready to include exhaustion of local remedy, so it's kind of a winning situation for India, because it has retained the period of 3 years and retained the provision of exhaustion of local remedy. If you will see the 2013 BIT, you will see that there is a clause of fork in the road clause is there. So when means you have to either you have to opt for the domestic courts, or you can go for international arbitration directly, which is not the case here. So of course the government, Republic of India, would have bargained a lot with the authority is in the on the negotiating table, and the UAE authorities definitely would have had a difficult time to include exhaustion of local remedy, because earlier the option was given to the authorities that you can either go to the domestic courts, or you can go for the international arbitration. So that also is, I feel that a winning situation. That's a winning situation for India. So overall, I'll say that if I have few more minutes, I'll just add few more points.
Sure,
That,
please.
we cannot say that. Yeah, we cannot say that it's a very government of India only has compromised. It's a compromise from the side of UAE also, because 7 years, 8 years, the negotiations were going on, and there used to be a dead end. I mean, the finalization of the text was never, being materialized. So, of course, both the sides deviated, and both the sides showed flexibility, and that's how we have the new BIT in picture. And of course, we can't say that portfolio investment, if it is included, it's going to bring lots of arbitration cases against India, because that is the argument which is made by few scholars, that if you this portfolio investment is kind of frivolous kind of investment. It's less than 10% in an enterprise, which was the case with model BIT when it was included. But it was very essential to include portfolio, because UAE side definitely would not have shown any flexibility when it comes to portfolio inclusion, and that is the difficulty India is facing with many other countries. They all want FPIs to be included. So, but we can say that India has balanced it through the provision of right to regulate, which was not there in the model BIT and in any other earlier BIT signed by India. So it's a provision which says that Government of India or Republic of India has got a regulatory power to regulate the kind of investments which are coming into the state. Secondly, we have a clause on denial of benefits. So when we have denial of benefits, government has retained that power to deny the benefit which is any frivolous company is claiming, or the companies which have only the motive of taking the benefit of ISDS claims. So that thing has been drafted in a very peculiar way, which is giving the regulatory power of the state is inherent, and it is being protected by the both the countries. It's not about only the investors of India, but at the same time UAE investors will also be getting these kind of benefits. The UAE state or the state of UAE also will be getting this kind of benefit. So regulatory power of the state has been taken very seriously by these states. So at the same time, I think it's a balance between regulatory power of the state and the investment protection given to the investors. So we will all these countries, the negotiations are still on. So we'll have to see what kind of flexibility it is showing. But I can say that this kind of compromise shown by India, at the same time retaining its regulatory power, because in the preamble also says that government will have its regulatory power. So in my opinion, it's a kind of very balanced BIT signed by the government of India, and it's definitely going to pave a way for its future BITs. And with this, I will just end my short presentation. Thank you so much to everyone.
Yeah, thank you so much. Thank you so much, Jyoti. Please stay with us because I'm sure there would be questions towards the end. Your points on the India UAE BIT are quite interesting, and of course I agree with you that there is some kind of flexibility that India has shown, at least in reducing the exhaustion of local remedies from 5 years to 3 years. But then there are also some features which you have not talked about, which actually are more radical from the India model BIT, and I can talk about that later. Okay, let me now turn to, so thank you very much. Let me now turn to our next speaker, Srijita Mitra. She's going to speak on investment cooperation and facilitation treaty between Brazil and India. So it's the India-Brazil bilateral investment treaty, if I can say that. Srijita, 12 minutes, please.
Yes. Good afternoon, everyone. My topic is, so I have kept my presentation a little compact and crisp. And it's an investment cooperation and facilitation treaty between the Federative Republic of Brazil and the Republic of India. And I've done a little critical analysis of it. So to begin with, it was brought about to, of course, strengthen the friendship between the two nations, Brazil and India, and for betterment of relationship. The most important point is the enterprise-based definition was brought about in this BIT, where an enterprise is taken together with its assets. The Indian model BIT requires the enterprise to satisfy certain characteristics of investment, which we all know, like commitment of capital, gain or profit, assumption of risk, and significance of development, which is specifically mentioned in Article 2.4. And there is a little sense of exception in this BIT, which is it focuses on the challenges that this can make the investors fall into. We'll come in detail later on as I proceed. How does it go to the next? Yeah, just a little touch to the basics and what is a BIT. It's a bilateral investment treaties, are international agreements establishing the terms and conditions for private investments by nationals and companies of one country to another country. And they're set forth actionable standards of conduct that applies to governments in their treatment of investors from the other nations, like fair, equitable treatment, protection from expropriation, free transfer of means, and full protection and security. Now I've done a little analysis of the BIT with the India model and just broken it down into 3 points, very crisp. Adopts a definition of an enterprise, which I had touched initially only based on investment. And there's absence of MFN concept, which we all are aware of. And there is replacement of concept of FET with the concept of treatment of investments. There is some issue with the button. It's just not going ahead. Yeah. So, my focus is analysis of this BIT. So what makes this BIT symbolic, different, and significant? First is it's a South-South agreement between two large growing economies. It abandons investor-state arbitration in favor of state-to-state arbitration with an increased focus on dispute prevention. And third, unlike most investment agreements, it expressly provides that a tribunal cannot award compensation. Instead, it only permits the tribunal to interpret the BIT or order conformity of any non-complying measure, a move potentially inspired with the WTO dispute settlement mechanism. Now, what effects do we have of the dispute resolution mechanism? Which is the exclusion of the possibility of investor-state arbitration, requires investors to depend on diplomatic avenues, because this is more state-to-state dispute and relationship that needs to be built. So the claims directly are difficult or almost impossible for investors to bring about against another state. So the functionality of the investors depends hugely on how diplomatic relations are existing between the two states, which is India and Brazil in this case. And this may hamper investor sentiment and prevent further investments because, of course, after finalizing its revised model BIT, India had sent notices terminating or not reviewing BITs that had expired at least 57 countries. The revised Indian model BIT was largely a result of a spate of claims against India after it lost the white industries case, which Sir had mentioned initially. And now it does pave a way for the global minds to rethink. It is almost me concluding my presentation. It was a little short, of course, but I wanted to keep everything together, which is since 2017, UNCITRAL Working Group 3 has been evaluating different options for the reform of investor-state arbitration. In Europe, European Commission has decided to cancel all intra-EU BITs. More than 168 BITs, including their sunset clauses, will terminate if and when the new multilateral treaty is ratified. So it's in the process. There is also a proposal by the European Commission to replace investor-state arbitration with a court structure. I'm really sorry because I'm struggling with the laptop here. I don't know if it's me or the laptop. Yeah. I have already done this, but it's. Yeah, okay. So, I will conclude this as basically that this BIT had, of course, initiated to strengthen the relationship between two states, but it brought in a very new concept to it, which is the state and state relationship. And it somewhere also gave more sovereign ability and power to the states like India and Brazil to act on its own and not give entire power to the investors, and everything to be resolved with between the two states. And so somewhere the domestic laws also get some kind of more importance in an international sphere in when we talk about international investment. And it takes into account for states to also put in their importance and views more into the diplomatic relations and take ahead relations, giving it more importance so that better investments can take place in the future, which is an example that we have with the UAE. And it shows how we have progressed from the India-Brazil BIT. Thank you so much.
Thank you. Thank you so much, Srijita. I now turn to our next presenter, Mahit Vidyasagar from DSNLU. He's going to talk about consistency and coherence versus finality. Mahit, 12 minutes, please.
So respected chair, my dear fellow panelists and the dignitaries over here, a very warm good afternoon to one and all. So today I would like to present you my views about the issue of consistency and coherence versus finality in investor-state dispute settlement system. Before going into the presentation, I would like to thank the Indian Society of International Law for providing this wonderful opportunity. And I also convey my sincere apologies to the chair and the dignitaries over here if I speak anything non-context or irrelevant because of my ignorance and lack of in-depth subject analysis. So moving on to the presentation, Prabhas Ranjan sir has already contextualized the ongoing debate that has been going in the international investment law and the reform process at the Institutional Working Group 3 level. So he made my job a little bit easier to present you the context that I wanted to present. The reform procedure that has been initiated by the Institutional Working Group 3 has once again sparked the ongoing long-standing debate of consistency versus finality in investor-state arbitration disputes. This debate, the core of this debate consists of two principles. One is achieving consistency for the ISDS decision, and another one is preserving the finality option of the investment arbitration disputes. So at this legal juncture, the scholars and practitioners was split on two issues: whether the investment dispute should be settled or they should be settled rightly. Because one presses that a greater consistency is necessary for for rebuilding the legitimacy of the system, and another expresses that for an efficient resolution of investment disputes, finality of the arbitral awards has to be preserved, and it should not be disturbed by achieving or by pressing for consistency. So against this background, I would like to emphasize on the theoretical underpinnings of both the principles and their practical implications in investment arbitration, as well as to emphasize on what is actually necessary for a better dispute resolution system. Moving on to the principle of finality. Principle of finality is one of the key attributes for investment arbitration. The theoretical basis of this principle can be found in the parties' autonomy, which respects that parties' choice of the dispute resolution system rather than the litigation itself. The principle of finality is embodied in the common law principle of res judicata, which explains that once a matter is settled between the parties, the same cannot be adjudicated elsewhere, or the subject matter cannot be disputed in any adjudication forum. So the principle of finality also finds its justification in the pursuance of an efficient dispute resolution system by limiting the options available for appealing or reviewing the arbitral award. The same philosophy can be found in Article 52 of the ICSID Convention, which specifically limits the ground for annulment of arbitration. The grounds that has been mentioned under Article 52 are specifically concerned with the procedural aspects of the arbitration itself, but not dwell into the substantive aspects or the factual or legal merits of the arbitral award. Likewise, Article 53 of the ICSID Convention also emphasizes on the principle of finality. It specifically states that once an arbitral award issued by the ICSID arbitral tribunals, it should be a final one and it is binding on the parties. And other one is, likewise, the principle of finality can also be found on the judicial review of non-ICSID arbitration, where the judicial review is usually takes place based on the grounds that have been mentioned under the UNCITRAL model, Article 34. As I mentioned about the UNCITRAL model, because most of the domestic states build their arbitration laws in accordance with the UNCITRAL model, or they have a similar kind of structure. So the grounds for reviewing the ICSID arbitration, or for that matter international arbitral awards, the grounds that has been mentioned under Article 34 will be similar to the ones under the domestic laws. So these grounds are also specifically concerned about the procedural matters, but not with the substantive aspects or the factual or legal merits of the case. Similarly, Article 5 of the New York Convention, which provides for the opportunity for setting aside of the arbitral award at the seat of arbitration while it is being enforced. So the grounds mentioned under Article 5 are also similar to that of the Article 34 of the UNCITRAL model. So these examples can be seen as the importance given to the finality of arbitral awards. If we look at the proponents that emphasize on the principle of finality, they specifically contends that finality promotes efficiency and cost effectiveness in dispute resolution, because by limiting the appeal options or reviewing options, it cuts the long-going adjudication process, and it provides an efficient dispute resolution. And moreover, this efficient dispute resolution process is not just a matter of convenience, but can have significant economic implications, because particularly when investment disputes involve large-scale economic issues, so the uncertainties in the legal procedure can impact the market valuations and national economic policies as well. Moreover, this finality also enhances the political as well as procedural neutrality, because if there was no principle of finality, the parties to international business transactions may have no reliable alternative to the uncertainty of third country courts or the perceived bias of the other side's hometown justice. So the binding nature of the parties also be reliable, made the parties to rely on the outcome and to plan their future investment strategies as well. However, the principle of finality is not at all without criticisms, because by limiting the options for appealing the investment arbitration awards, it results it creates a significant problem for correcting the arbitral awards which contain the manifested errors of law. The same has been acknowledged by the ICSID ad hoc committee in the case of CMS versus gas transmission, where the tribunal specifically quoted that it was unable to rectify an arbitral award, even if it is identified the manifest errors of law that has been in the award. So, moreover, the principle of finality also results in the incoherent development of jurisprudence pertaining to the prominent issues, including the standards of investment protection and customary international law principle that governs the investment arbitration. And the scholars particularly also emphasize on the issue of power imbalance that this principle of finality actually creates between states and investors, because the binding nature of awards combined with limited review mechanism may place undue pressure on the states while defending or complying with the unfavorable decisions which contains manifest errors of laws. On the other hand, if we look at the principle of consistency in a legal system refers to the uniform interpretation and application of rules across similar or identical cases. According to the scholars, a legal system is said to be coherent if it treats is said to be consistent if it treats identical or similar situations in the same way, and if it gives equal treatment to the participants in the system. So an emphasis of consistency also promotes equality among the litigants, constrains idiosyncratic decision making, and increases the perception of legitimacy of the dispute resolution system. So having a consistent adjudication process, it fosters certainty in how legal rules have to be applied and interpreted, which is essential for the stability of any legal framework. And it is specifically essential for the investment arbitration disputes, because investment arbitration disputes always involves the matters that touches upon the public policy or the regulations made by the host state. In such a scenario, a harmonious and unified construction among the legal rules is very necessary. If there is no such harmonious construction among the legal rules, then the outcomes of the dispute resolution will be depends on a mechanism which is full of legal uncertainty, which is actually happening in ISDS cases. And however, in the words of Gabriel, Confon, and Kohler, the credibility of the entire dispute resolution system usually depends on consistency, because a dispute settlement process that produces unpredictable results will reduce the confidence of the users in the long term and defeats its own purposes. However, achieving consistency is also not without challenges, because the critics clearly point out that investment arbitration disputes involve varied treaties as well as varied host state laws. So in such a scenario, pressing for rigid consistency actually hampers the flexibility and adaptability of the investment arbitration system. So they point out that some kind of flexibility is actually necessary for the dispute resolution system. So achieving consistency is not a desirable option. However, through my presentation, what I would like to point is it is not completely consistency that has to be needed for investment arbitration. Coherence is what actually necessary for ISDS disputes. Coherence, which may seem as synonym to consistency. Consistency refers to the treating of similar cases alike. However, coherence refers to being logical and consistent. According to the scholar,
Mahit, I'm sorry, would you like to conclude, please?
Yes, sir. I'm about to conclude it. So an idea, reason, or opinion is said to be coherent when it is clear, well considered, and each part connects or follows naturally in a reasonable way in the context of legal systems. And coherence is specifically essential for establishing legitimacy, as it creates internal harmonization. Coherence helps for the development of legitimacy as a whole, and it also the necessity for the principle of coherence has also been acknowledged by the arbitral tribunals in the case of Vivendi versus Argentina. In the words of the tribunal, considerations of basic justice would lead tribunals to be guided by the basic principles that like cases should be decided alike, unless a strong reason exists to distinguish the current use from the previous, which means in order to deviate from the previous line of decision, the tribunals has to develop a legally permissible reasons. These legally permissible reasons are those employed by the arbitral tribunals that reflect greater coherence and integrity. So this refined notion is what actually necessary for ISDS system in order to rebuild its legitimacy and to continue as an efficient and effective dispute resolution process. Thank you, sir.
Thank you. Thank you very much, Mahit. That's a very interesting topic on consistency and coherence. And for students of international economic law, it would be very fascinating to note that if you look at the international trade law mechanism in the WTO, where the appellate body actually played a critical role in bringing consistency and coherence, and today that appellate body doesn't exist because the United States didn't like that consistency and coherence. And in investment law, countries are negotiating to create a mechanism whereby you can have consistency and coherence. So one system has moved away from the appellate mechanism, and the other system, the cousin of trade law, is trying to move towards an appellate mechanism. So this is a very interesting dichotomy for us to note. Okay, thank you very much. I now turn to our last speaker, Mr. Apologies if I mispronounce your name, Kajanwali Sheikh. Yeah, thank you so much.
Very good evening to chair and fellow panelists and all the dignitaries. Today, I stand here to address one of the most pressing challenges of our time. A challenge that affects every breath and we take, every drop of water we drink, and the very future of our planet. I'm talking about the how international business agreements have created a system where corporate profits often trump over environmental protection and human rights. Let me give you an example, a real example that will illustrate the gravity of our situation in 2022, where when Germany, one of the world's leading economies, decided to phase out coal power to combat climate change, they faced a staggering 1.7 billion euros lawsuit from an energy company. Think about this for a moment. A sovereign nation attempting to protect its citizens and contribute to global climate action was essentially penalized for doing the right thing. The scale of the problem is staggering. According to the latest World Investment Report 2023, we have witnessed 1322 known cases where corporations have sued government under international investment treaties. These are not just numbers on a page. Each case represents a battle between corporate interest and public welfare. Nearly a third of these cases were won by the investors, with awards often reaching hundreds of millions of dollars. The average legal defense cost alone about 4.9 million per case. This amount could fund vital environmental program or public health initiatives in many developing nations. Let's look what happening in our own backyard. India's experience in particularly telling. Our nation has faced 28 investor state disputes with 7 decisions favoring foreign investors. The Can Energy case resulted 1.2 billion award against India, while the Devas Multimedia dispute led $1.3 billion penalty. To put this number in perspective, the total amount awarded in just 2 cases could have funded clean water process for millions of citizens or powered millions of homes with renewable energy. And at this point of time, I will also conclude that I will also wanted to say that it is only not about monetary cost. The UN Environmental Program has revealed a disturbing trend. 90% of developing countries have delayed implementing environmental regulations because they fear expensive investor lawsuits. This means governments are hesitating to protect their forest, clean air, and safeguard their water resources, all because of the threat to billion-dollar lawsuits. The environmental stakes could not be higher. We are losing 27 football fields worth of forest every minute globally. Air pollution claims 7 million lives annually. 1 million species face extinction due to human activities. And while these crises unfold, the very tools we need to address them, strong environmental regulation and protective measures are being undermined by an international investment system that often prioritizes profit over planetary health. In other hand, over 40% of new investor state disputes in 2023 challenge environmental protection measures. Fossil fuel companies alone have won over $100 billion in awards challenging the climate action. That 100 billion that could have been invested in renewable energy and given a lot of facility to the people. These crises demand our immediate attention because it's not just about abstract legal principles or distant corporate boardrooms. The current system created what legal scholars called as regulatory chill, where governments hesitate to implement necessary environmental regulations out of fear of investor lawsuits. This paralysis comes at a time when we need bold environmental action more than ever. Global temperatures have already risen 1.1 degrees Celsius above pre-industrial levels, and every delay in environmental protection brings us closer to catastrophic climate impacts. And in our recent UAE bilateral investment treaty also, there is no much discussion about environment and human protection action about that. And we have witnessed many cases till time. Every time government ignores that prevention is better than cure. After getting affected, then only government is getting awake. As we delve deeper into this issue today, remember that that these are not just statics. They are warning signs of a system that needs urgent reform. Now, with this, the problems are very clear, but solutions exist. In the next part of our discussion, we will explore how we can reform the system to serve the both people and planet, because ultimately the choice between economic development and environmental protection is a false one. We need both, and we need them now. Here are the key challenges we face. The power balance. When country tries to pass laws to protect its environment or its people's health, foreign companies can challenge these laws through a system called ISDS, Investor State Dispute Settlement. It's like having a game where one player gets to be both player and referee. These companies have already won $100 billion, as we told. In a report, Special Rapporteur of United Nations Human Rights and Environment, Mr. David Boyd, also, as Ranjan Ghosh has said, where awards are not publicly available, David Boyd called his ad as secretive international arbitration is leading to the mislead and what we can say, there is much ambiguity on the process of ISDS. And next, this environmental crisis, let's look at what's happening on the ground. In India, climate change is not just about a future threat, it's already here. By 2030, India could lose 34 million jobs due to rising temperatures. That's more than the entire population of many countries. Meanwhile, our environment continues to suffer. Rivers are getting polluted, forests are disappearing, and air quality in our cities is getting worse. Impact on local communities. For example, in Tanzania, when the government tried to stop project that would have displaced 1,000 people and will damage a national park, Tanzania got sued for $165 million. This money could have been used for schools, hospitals by the Tanzania. Without proper framework and legal framework, going forward, Tanzania faced a huge amount of loss. The indigenous people struggle. Native communities who have protected their lands for generations are often completely ignored when big investment decisions are made. They can't even properly participate in the international court cases because they are too expensive and complicated, such as to take part in arbitration and to approach the international forums. For indigenous people, it costing too much. Even companies are not able to bear in the meantime. And one more thing, in India, these multinational corporations to getting people hired for low wages and getting work, and a real life impact on the people also getting. Let me share a recent story from 2024. Anna Sebastian Perayil, a young chartered accountant in Pune, India, died reportedly due to extreme work pressure at a multinational company. This tragic case shows that how the drive of a corporate profits can have a real human cost. Really, these companies are based in other countries and getting through some investments into the India and putting a lot of pressure to get work done. These are not taken by the. This is taking have real human cost. And what needs to change? Let me know outline.
I'll request you to conclude, please.
Yes,
thank you.
Sir. We need new types of treaties that explicitly protect both human rights and environment. The treaties must give local courts to the authority they need to handle disputes effectively. I think of its rewriting the rules of the game to make it fair for all players, not just the most powerful players. Monitoring must become More rigorous, transparent, regulatory checks on company behavior should not be optional. They should be mandatory. The public deserves access to the information about how international investments affect their environment and communities. Transparency breeds accountability, and accountability drives responsible behavior. And balanced development is ultimate goal. We just reject the false choice between economic growth and environmental protection. Sustainable growth is not just a buzzword, it's the only way forward. Every investment decision must consider its long-term impacts on both the economy and the environment. True progress demands more than profit margins. It requires creating a world where clean air, water, and soil are not luxury items, but these basic rights. Our investment agreements must reflect this reality. They must protect both economic interest and environmental heritage. Thank you.
Yeah, thank you very much for that presentation. I think we have done well on time. I thank all our speakers for being so disciplined and sticking to the time. And we have about half an hour for discussion. I think it's very important to have ample time for discussion, because it can't be or should not be a one-way street or just a dialogue from one side. So I'll now open the floor. You're most welcome to ask your questions or make your comments. Please identify yourself and please tell us to whom your question is addressed. Yes, Rashmi, please.
My name is Rashmi Salpekar, and I have a question to you and all the panel also. If any one of you please respond. Now, regarding the provision of MFN and our Model India Bilateral Investment Treaty, as we know, and the panelists, they have also mentioned that MFN is not mentioned explicitly in our bid, but we say that in spirit it is there, if you will read the provision also. Now, my question is that when we draft treaty, there are few principles which are required to be there explicitly, isn't it? And MFN is also one of the same. We are also party, or we are also state member of WTO. Therein also MFN, national treatment, all these provisions are there. So as such, MFN is not very foreign to us. We are already under the obligation for MFN, being member of WTO. So how conveniently we are not mentioning it explicitly in the in our model bilateral investment treaty? And if it is so, then how far we can go ahead like this? So what about, there must be some principles to be followed while drafting the bilateral investment treaties. Tomorrow maybe some of the foreign investor right may also not be mentioned explicitly. Again, we will say that in spirit it is there. So how it goes? Thank you.
Okay, thank you. I'll turn to Dr. Pereira to answer this question. I'll also offer some comments, but I propose that we collect a few more questions before I turn to the panelists. So any other question that anyone has on MFN or on any other topic that we have discussed? We have discussed a wide range of issues in international investment law. Any other comment or question? Okay, maybe people can think about asking the questions. Dr. Pereira, would you like to take that question? I hope you were able to hear the question that was asked on MFN.
Yes, Mr. Chairman. Thank you very much.
Yeah.
Well, this was also going through my mind. If you are silent on MFN, the treaty, can it be read into the treaty as ensuring minimum standard of treatment? So I would also like to hear the experience of dropping different laws altogether. So that development is to be, that is what I would say at this stage.
Yeah. Thank you.
Thank you.
Yeah. No, please go ahead.
The second point is again the mention of appellate procedure, which again is interesting avenue to pursue, because as you know, under the clause statute, there is no appellate procedure. It's only on very limited grounds proceedings for nullity. So it's another avenue we need watch out.
Right.
Thank you very much.
Yeah, right. Right. No, thank you very much. My 2 cents, Rashmi, on your point. As far as my understanding goes, MFN does not have a basis in customary international law. It's a treaty principle. So if it is missing in a treaty, then we can say that MFN doesn't apply. Which in other words means that even if India is bound by the GATT obligations which contains MFN, if it doesn't contain the MFN provision in a particular bilateral investment treaty, then as far as that investment treaty is concerned, the MFN provisions will not apply. Which means that the foreign investor will not be able to borrow a beneficial, substantive, or a dispute resolution provision from a third country BIT. In fact, it's not surprising that why India has excluded MFN. Although, in my opinion, and this opinion is not very popular, it's a dissenting opinion. In my opinion, not having the MFN provision is an extreme solution because India decided not to have the MFN provision in order to ensure that there is no repeat of white industries. But that problem can be tackled by having the MFN provision formulated in narrow terms. So as Dr. Pereira mentioned, and as ILC's work on this also shows, you can have a MFN provision which is tailor-made to exclude the possibility of the investor borrowing beneficial provisions from third country BITs. If you look at the EU practice on this, it's very instructive. The EU-Canada Comprehensive Economic Trade Agreement, or the EU-Vietnam Investment Protection Agreement, EU-Singapore Investment Protection Agreement, they have the MFN provision, but they very explicitly say that this applies only to the treatment that is given on the ground. So unless or until on the ground, I am not discriminating between two foreign investors, no foreign investor can bring a MFN violation or MFN claim against me. So that would ensure that a white industry scenario doesn't happen. But at the same time, that would send out a positive signal to the investors that we have MFN and we will not discriminate against you. Because at the end of the day, let's appreciate this fact that investment treaty is a major signaling exercise, right? And this is especially true for countries like India, which officially has said that we want to increase the annual FDI levels to so many $1 billion, right? So we need FDI, and if you need FDI, then you need foreign investors. And if you want foreign investors to come, then you have to give them protection. So the argument is that, well, we can give them protection under domestic laws, and they don't need to worry about any other protection. But then that may not be enough. If that was enough, then these countries would not be asking for India to sign investment treaties. The fact that many of these countries are asking India to sign investment treaty means that while they have faith in the Indian legal system, they do want something extra, right? And that extra perhaps is the investment treaty that does the work. But of course, as I said, mine is a dissenting or a minority opinion. The majority opinion is that, we don't need these treaties, and investors are anyway queuing outside to invest into India, which of course can be tested. Yes, any further? Yeah, Anwar, please. Yeah. You go ahead, then I'll go.
So, climate change consideration in the bilateral investment, because there are many companies that have declared that they will become carbon neutral, and they have expressed carbon neutrality. There are states, of course, India, like 2017, the Paris Agreement says. Paris Agreement says that by 2050 we have to become carbon neutral. So companies have also, multinational companies, they have said that they will become carbon neutral. Some of them, I don't know, maybe 2030. So in bilateral investment treaty, are they maintaining the same spirit that I have no issue? So climate change consideration, if it is there.
Yes. I'll let Karishma and Kajavali to answer that. But let us take Dr. Singh's question.
Thank you. As you mentioned, the white industries case is often referred to as the invoking of the MFN clause, and the tribunal did refer to the access to justice clause. But question is, did they really need to do that? What if there was no access to justice clause to which they could refer on MFN basis? Because regardless of the MFN clause, you have the obligation of fair and equitable treatment. And the grievance in this case was the long delay in ruling on an arbitral award given in favor of White Industries for a contract which they had entered into with Coal India Limited. Now, one argument which is often made is that it is the big multinationals who come in and exploit and take advantage of this. Now, in this case, in this particular contract, who is the dominant party to the contract? Between White Industries and Coal India, I think not many people here are aware that Coal India is the biggest coal mining company in the world. It controls 80% of the coal mining in India. White Industries is a small engineering company which entered into a contract to enhance production in one of the mines in Australia belonging to Coal India. At the end of when the contract had been completed, the contract provided for a reward for satisfactory completion, which Coal India refused. And there was an arbitration, and an award was given in favor of Coal India. And this award, they spent 12 years trying to implement and to get the benefit of the award which was in their favor. And finally, they got tired of waiting and went for the arbitration. And what is the reaction of our legal community? Oh no, they were aware that we have delays in India. So they should wait. They should be happy that it was only 12 years they waited. And what statement does our Chief Justice make? Every Chief Justice in India, during his tenure, at some point or the other, he declares very loudly in various seminars and occasions, saying justice delayed is justice denied. But when justice is delayed to a foreign investor, you say he should not complain. He should not say there is denial of justice. So in my view, the MFN clause was irrelevant in this case. It's only incidental that the panel would locate such a clause, or the counsels for the company White Industries found this clause and invoked the clause. And after White Industries, what was the reaction of the Supreme Court itself? Well, they took it as a wake-up call, and they changed their position of trying to intervene in every arbitration and trying to characterize every international arbitration on the same basis as any domestic arbitration. Even though the Act has separate chapters, they had virtually done away with that distinction. Now, you just mentioned another point, that a lot of people say that we don't need investment treaties. Now, when did India start to negotiate these investment agreements? In a time of crisis. When India, after being resistant to foreign investments for a long period, after adopting policies which led to companies like Coca-Cola and IBM leaving India, you adopted policies requiring foreign companies to dilute their foreign equity. And that foreign equity was diluted not at market prices, but at prices decided by the controller of capital issues. I know this movement led to a lot of people entering the stock market because they thought that this is an instant riches. All the shares which they got at very highly discounted prices, they benefited from the real market prices. Now, what does a foreign investor look for? He looks for clarity in the law, and he looks for certainty. and the uniform application of that law. That is what is important to the foreign investor. And if he has a dispute, we have seen before, not only in the investment treaties, but in our oil exploration program in the Bay of Bengal and in the Arabian Sea, when India advertised for companies to search for oil in these areas, there was absolutely no response. When India took up the issue with individual oil companies as to why they were not responding, they disclosed that they would not accept domestic dispute settlement either by the courts or through arbitration conducted in India. It was a complete lack of confidence. They said, only if you allow foreign arbitration, we are willing to undertake exploration activities. And the same happened in the investment agreements. Every investment treaty provides a clause, a fork in the road, that the investor can choose to approach the domestic remedies, or he can go for international arbitration. Till today, no investor has chosen the domestic settlement route. But we also have to understand that it is not every dispute which can be taken to international arbitration. It is disputes under the treaty. Because disputes under the treaty are different from other commercial aspects on which disputes may arise. And the treaty does not guarantee profits. It only guarantees a level playing field, that similar benefits will not be given to anyone else, and that they will not be discriminated against in certain matters against domestic companies. Now, what did we have in practice? We had the Japanese company Docomo. They entered into a partnership with Tata Telecom. It did not work. They had incurred losses and they were withdrawing their investment. So what do we get? The income tax says that we will put a tax, we will treat this as income. They have made no profits, but income tax wants to levy a tax. The Reserve Bank of India places hurdles in their repatriation. So if this is the way our laws are implemented, although the treaty allows investors to repatriate their investments as well as their profits, even the amount remaining after the losses, when the company tried to take it back, hurdles were placed and the matter had to go to court, and finally they were allowed to take away their investments. Even though in matters of acquisition, running their investment, acquisition and disposal, they have national treatment. Now this was similar to a partnership agreement in which one is a sleeping partner who says that he's guaranteed a profit or he's guaranteed no losses. So Docomo was in that situation.
Yes.
And when the agreement provided that there would be a limit on the losses which they were ready to incur, and beyond that they were then wanting to take the investment away.
Yeah.
So we had the problems on that. Enron, what was the difficulty? It's a clear contract which provided that Enron will set up the power plant and supply power, and they will be paid at certain rates, or there was a formula according to which they have to be paid, and they were not paid. And
Dr. Singh, I'll request you if you could conclude.
I know. I'm sorry I'm taking so much time, but this is a subject which I have been handling for a very long time.
Right.
And therefore, so the issue is here that most of the investor disputes we have had are self-inflicted. And we have to recognize that. Even when the telecom companies, after their licenses were sort of held to be invalid, the Secretary Telecom says, but we didn't sign this agreement, this investment, it is Finance Ministry. I said, no, it's Government of India. And you are given licenses which your court has held are not valid. And on the basis of those licenses, they have invested big amounts over here. So you cannot say that you are not responsible. So thank you. I think I've taken enough time.
No,
thank you.
Yeah, that was wonderful to hear from someone like you who has dealt with this, because this, as I said, is a contrary view, not a very popular view in India. The popular view seems to be that, we don't need these treaties because we are anyway getting high levels of foreign investment, but that has to be taken with a pinch of salt. On White Industries, I'll just quickly say that the investor did bring a claim on the FET violation as well. So they brought a claim on denial of justice as well. But it was a 9-year delay, which the tribunal said is not significant enough to amount to denial of justice. But they were able to find this favorable provision, which specifically was effective means for addressing claims and enforcing rights from the India-Kuwait BIT into the India-Australia BIT. Before I open the floor further, Jyoti, would you like to add something on this? Because I think you might have a different opinion on this, on the MFN issue.
MFN issue, actually, most favored nation treatment is something which India is always, after the White Industries case, India has been wary of this particular provision. But at the same time, as you mentioned, Ancestral Working Group and ISC also has given some kind of formulations which can be an alternative to the popular MFN provision, which is being incorporated in generally in other BITs. So when sitting on the negotiating table, those formulations have already been discussed, and the formulations are being exchanged between the countries. The only thing is that both the countries have to reach on a common ground that if we want to have most favored nation treatment clause, it has to be in this particular manner. So for that, the policymakers are already, in that kind of frame of mind that if we want to have MFN, it should be in this manner, and the other country or any particular country should not be able to import the dispute settlement mechanism or any other mechanism through MFN. Because MFN's main primary motive is to give non-discriminatory treatment to the third countries. So that is the primary motive. So of course it's not a kind of the lethal provision which it has been made to be portrayed so, but actually it has many other motives also. So according to me, the policymakers are already have kept this in their mind, and formulations are being exchanged. So that is my point. Secondly, I just want to briefly add here that you have rightly mentioned that in White Industries case, FET, expropriation, transfer of funds, all those provisions were, asked by the councils. They were all the provisions which had been used by the councils against Republic of India. But that particular provision of enforcing claims and the rights, enforcement of effective participation of enforcement of rights was something which was utilized through MFN, and it was just a coincidence. But the other provisions were discarded by the tribunal, and that provision became a ground for MFN being exported. That is my point.
Yeah, no, absolutely. But it's also interesting, Jyoti, to note that the India UAE BIT also doesn't have the MFN provision. So if we were to take this as an example of the latest in India's investment treaty practice, we still find that India is sticking to, while India has departed from the model on some of the issues which you highlighted in your presentation, such as exhaustion of local remedies being brought down from 5 to 3, or inclusion of portfolio investment into definition of investment. On the MFN issue, I think India is still holding up onto its position. Now, I don't know whether it was because no other alternative text on MFN was discussed, or maybe was it because India said that no, this is a no-go zone for us and we'll not negotiate on MFN. I don't know what the people in the government would be able to comment better. But related to your presentation, Jyoti, I have one sort of specific question on the India UAE BIT. If you look at Article 14, I don't know the exact number. I think it's Article 14.5 or 14.4, which says that if there is an allegation of corruption, fraud, money laundering, etc., against the investor, then the investor cannot bring a ISDS claim against the state. Now, what is interesting here is that a mere allegation is enough to suspend arbitral proceedings. So I want your quick take on this. What do you think on this? And second question is also on, do you think that this is going to be India's new investment treaty practice that we have in the India-UAE BIT? Or is it an aberration and India will stick to its model BIT for other negotiations? Quick responses, please. Thank you. Jyoti, are you there?
Actually, regarding the 14.5, Article 14.5.5, as you have mentioned here, is regarding allegation of fraud and corruption. So before that, 14.4 actually, is with regard to the judicial decisions, which has actually, endorsed the corruption or fraud in any of the company. So I think this 14.4 is more important. The logic behind 14.5 will have an elaborate discussion with you maybe separately. And regarding this particular BIT, what I have to add here is that the BITs are being negotiated case to case basis nowadays. So we cannot see that this is a tight bracketed the BIT which is going to be negotiated. I mean, this cannot be a formulation with which India can go with other countries, because Western countries have different priorities. UAE had different priorities, and we cannot take that this thing that this is going to be the model kind of thing which is going to be with other countries also. It has just given a hint to other countries that India is ready for flexibility.
Yeah.
India is ready to sign the BIT, but that needs to be seen. Like I said that maybe UAE BIT does not have MFN, but at the same time, other countries might not compromise on the provision of MFN, and they might have it in other diluted forms. So that has to be seen.
Yes,
and
right.
see.
Right.
The gates have already been opened.
Yeah, right. Thank you. Thank you very much. Although I personally find 14.5 a little complicated, because in a way it says that if a foreign investor brings a claim against the state and then you allege corruption against the investor, the arbitral proceedings will stand suspended. And alleging something is very different from actually proving it in a court of law, right? Okay, we had, quickly.
Just wanted to add that when allegations have been already hurled against an investor, that needs to be investigated. So it's only saying that the arbitration will be suspended. Till the time the investigation is being done, the arbitration may be suspended if the allegations are proved to be wrong.
Yeah, but in India we know that allegations, investigation takes a whole lifetime, right? So yeah, but anyway, that's fine. Thank you very much. I'll now turn to other panelists. There was a question, although Anwar has left, there was a question on how investment treaties are able to carve out environmental provisions. So Karishma, if you could quickly respond to that.
Yes, although Anwar sir is not here, let me try to answer the question in 3 pointers actually. So first, I would like to say if companies are investing or going towards carbon neutral, I mean, it does add to the factor where the investors are helping the state to achieve its climate obligation. So it's an add-on factor. Another point that I would like to mention is in relation to the BITs that I mentioned and the environmental provisions that it had. So there is no specific element as such, if I could recall, in relation to investors being a carbon neutral, but it does point out that investors should also strive towards achieving the climate obligations of the state. Thirdly, I would also like to point out the on the basis of my limited research on carbon neutral, the policy of carbon neutral by investor states. So some scholars have pointed out that there is not a specific mechanism as if we say that if companies are accommodating the policy of carbon neutral, so we could see the results for specific, suppose in their policy documents as such, but there is no set mechanism to evaluate if that carbon neutral or how much percentage has been achieved. So that is an element that a mechanism should be made, was a point that has been made by some of the scholars. Thank you.
Right. Thank you. Yes, please, very quickly. Yeah.
This environmental conjoint curve, which shows the relation between economic growth and environmental pollution, these are growing together in India, because in India, as of now, India is dependent on fossil fuels 76% what they are consuming today. For this, after signing Paris Agreement in 2016, India is working towards renewable energy by using wind and phototype technologies, which is helping to bring down the carbon emission. And India is committed to bring the not to be take global warming more than 1.5 degrees Celsius in coming days. For this, India promised to be help to the new industries which works on renewable energy, but as on date there is no remarkable support from the government of India to establish green energy projects. It is very limited. If we wanted to achieve these goals, we should depend on renewable energies. Then only global warming will come down.
Okay, thank you very much. Since we are almost out of time, any other final questions that anyone has? Okay, I'll then turn to the panelists one by one if they have any final comments to make or any sort of, if I may just quickly ask a question to Mahit on the appellate mechanism. I don't know if you have noticed this or anybody else in this room has noticed. If you go to the website of the UNCITRAL Working Group 3, you would find submissions made by several countries. There's one name which is missing there, and that's India. And as a student of investment law, when I was doing my research, I was very anxious to know what is India's stand on the appellate mechanism. And I could not find any submission that India has made to this. Although I know unofficially that India is participating in these negotiations. So you have countries like Brazil, you have countries like South Africa, Argentina, large number of developing countries that have made submissions, but India hasn't submitted. And this is quite contrary to India's reputation as being a very active intervener in all international negotiations, WTO, climate change, etc. So what do you think is the reason? If you could speculate. I know you don't work for the government, so you will not know, but if you could speculate quickly.
When I am researching for my thesis, which is specifically on the appellate mechanism, I felt the same issue. Even though India is being a participant, why is not making any specific submission? And it is essentially necessary for India to actively participate in the discussions, considering the parliamentary committee report as well. Even though India has attained a status as a most favored destination for FDI, the parliamentary committee itself has stated after the finalization of 2015 model bid in 2021, in its committee report, it felt a little bit dissatisfaction for gaining large number of bilateral investment treaties. And there are several reasons, like as we have already discussed, one of the reasons is the issue with the MFN clauses, or one of the reasons with the exertion of local remedies. Add on to that, the enforcement mechanism of investment arbitration disputes is also another issue, which you have highlighted in your article as well. So considering India is a little bit favorable for the appellate mechanism also, because in its model treaty also it showed its interest for submitting the disputes if at all an appellate mechanism is formulated in the future. So there is a pressing need for India to highlight the specific concerns with regarding to the appellate mechanism.
Yeah, right. Thank you. Thank you so much. And one question to you, Srijita, on the India-Brazil. So firstly, do you think it's an investment treaty? Because some people say it's not really an investment treaty, although I disagree with that. And secondly, do you think that investment facilitation is the right way to go forward? Or do you think investment protection has to be at the heart of any investment treaty? Quick response, please.
Hello. I also think this is an investment treaty to begin with, and investment protection, I think, forms a very significant role of any investment treaty that a state enters into. So, giving protection to investors is, of course, needed, but also I think the angle that these investment treaties are taking is where the state holds some extent power, like the sovereign power to bring it down to the domestic level is important, because then otherwise it entirely somewhere goes into the investors' hands. The entire power of how they will invest and the entire control of legality somewhere depends on that. So we being an emerging and one of the largest growing economies, I think to some extent that power should be in us, and also a little outline in the treaty where we give them enough, show them enough interest so that they, of course, because we depend on our FDI to that extent.
Right. Thank you very much. I think it has been a fascinating panel. I would like to thank all our speakers, Dr. Pereira, Jyoti, Karishma, Srijita, Mahit, and of course, Khajawali for their excellent presentations and for sticking to time. I can't resist but say that when I started researching on international investment law in 2006 as part of my LLM dissertation in London, there was hardly anyone in India who was working on these topics. In fact, I remember an old academic telling me, why are you wasting your time doing research on international investment law, which no one knows about? But 18 years later, I can say that things have changed quite a bit. And I suddenly start feeling older in the company of these young researchers, although I must say I'm not very old. And I'm very happy to see that there's so many people doing work on international investment law, writing their PhD dissertations on international investment law. This is an area which definitely requires a lot of expertise. A lot of capacity has to be built in India. And this is true for international law in general, but international economic law in particular. And I wish all of you good luck. So international investment law is definitely at crossroads, and we need what Anthea Roberts and Nicholas Lamp have called in their book on 6 Phases of Globalization as meta-narratives. We don't want just one narrative to dominate. There is the popular government narrative, but then there are other narratives also which need to sort of exist along with it, because it is only through the study of different narratives that we'll be able to synthesize that what is the right way forward. I don't think anybody knows what's the right way forward. Anyone who claims that he or she has all the wisdom is definitely either living in fool's paradise or wants us to, believe something to the contrary. So I once again thank ISIL for this opportunity. I thank my fellow panelists, and I thank all of you for staying with us for these 2 hours. We have done well on time, and now we all can enjoy a cup of tea. Thank you so much.
Now I would like to request Mr. Anupam Jha, Treasurer ISIL, to facilitate Dr. Prabhash Ranjan with the memento.
Thank you so much.